Okay. Okay, let's do it then. And we have the live broadcast. Okay, we're back in session. We took a break for a technical glitch, and we understand the live stream is back on. We are on agenda item C3. There are some folks with some additional questions, so I will go to Dennis, then Mike, and then Patty. Did you want to ask a question? No. Okay. So Dennis first, then Mike.
Okay, so just hopefully we're going to wrap this up here shortly. But anyway, so we're going to basically run in two programs. We have the Native Hawaiian housing block, which we've already approved, and then we have this other abbreviated Native Hawaiian housing grant of $5 million. So primarily we're using the grant, the C2. We're using that for our beneficiaries, correct? And then on C3. We have this special fund from the congressional our congressional representatives that says you need to use this primarily for Native Hawaiians. But if there are beneficiaries that don't have, and we do have funds left, that they can apply for these funds. Is that correct?
Yes.
Even though we're assuming that those funds are going to be gone. I'm satisfied with them, with this happening, as long as if we can get one or two or whatever, so that we're not in conflict. That's all I'm looking for. So we're not working two separate programs. And I know, I understand what the congressional group was trying to do, and we appreciate that. But it does put us in a conflict when they give us something like this and say you have to do this for these folks, even though that is not your primary responsibility as a commissioner. And it does put us in a little bit of conflict with our beneficiaries, because how much you're going to spend on that, how much you're going to spend on this. So it's hard to tell a congressman that, but they need to understand that sometimes that throws a wrench into our process. But I'm satisfied with that, as long as Commissioner Kapu said, if there are funds available, they could go for those funds. If there aren't funds available, those funds are gone. The housing grant on the C2 continues on and on and on and on. So I'm satisfied with that. Thank you.
And only caveat to that is as long as there is a COVID emergency, right? Because that's what all these funds are for. Okay.
Got it.
So we'll go to Mike and then Ryan.
Thanks, Chair. I wanted to request to ask Ryan a question in executive session.
Okay. You got to make a motion, and then we need a commissioner to agree with you.
I'd like to make a motion to go into executive session to ask the AG a question about C3.
Okay. Good. We need a second.
Second.
Okay. All those in favor of going into executive session, please say aye.
Aye.
Anyone opposed? Seeing none. Okay, give us a minute because we have to And we got everybody back in that wanted to be in on the open meeting? Think so? Okay. Okay, we're back from executive session, back into open session. Are there any other questions regarding agenda item C3? Okay, great discussion. All those in favor, say aye. Aye. Anyone opposed? Seeing none, the motion carries. We will take a 5-minute break and then go to the J agenda before we go back to the HSD items. Okay? Short recess. Mahalo for giving all that thought. Okay, commission meeting is back in session. We will go to the J agenda item and see that in. So we'll go to agenda item J2, Blossom. Hello, Blossom.
Good morning, Commissioner, Chair.
Hello.
So once again, we come before the commission. I want to thank you for the opportunity to bring more information from your beneficiary community on Maui. I do want to start off by extending my congratulations to your staff for their success in securing over $70 million in CIP funding. While it is not as much as we would have liked, it is far more than what we expected, considering the financial situation of our state. And this funding will provide for some movement forward for existing projects currently on your development schedule. I also want to inform the commission that due to the work of Hawaiian Community Assets and their partners, along with your beneficiary community, the county council and the county administration has made homestead developments part of their plan to increase housing opportunities by providing some funding to help offset the cost of offsite infrastructure. Your LDD administrator, Stuart Matsunaga, as well as your planning division, Andrew Choi and Julianne Cachola, have been very helpful in providing our beneficiary communities with the information necessary to move our projects on Maui to the next stages. In particularly, the funding being made for the development of Pulehunui is most welcome, and your beneficiary community looks forward to the beneficiary consultation process for this much needed economic opportunity. Over the course of the past year, there has been opportunities presented to the commission regarding what was previously known as the Undivided Interest Awards. The Kuhio Awards process provides beneficiaries on the wait list, particularly those that have been on the list the longest, an opportunity to secure the rights of the listee and have the ability to transfer to their family members who would otherwise not be eligible to secure a lease of their own. Since the beginning of 2021, we have experienced the loss of 5 kupuna that are on our wait list for Maui Island. None of their children or grandchildren would qualify as a successor to their place on the list due to lack of sufficient quantum or age. There has been more and more discussion among beneficiaries who are feeling somewhat pressed to address the issue of kupuna on the list and their demise and the loss of the opportunity. As a way to address the issue, the department embarked on the UI lease award as a way to resolve the issue surrounding the long wait to the applicant wait list. And as a new program, it is natural for some challenges to emerge. One is a long wait for development and a lack of communication with the department staff and beneficiaries. So as such, I would like to make some recommendations that hopefully can address these challenges. Regarding the long wait for lots, when we signed our leases in 2005 with a promise from the department that lots would be ready in Waihuli in 2008. In the meantime, homestead lots are awarded in Waihupo 4, in Leali'i, and in a scattered lot offering, none of which are offered to the undivided interest lessees. At a meeting with the lessees on Maui, it was noted that we had not received a notice of lot offering simply because we agreed to wait for lots in Waihuli. And since we're unable to secure a response from the department as to when lots in Waihuli would be available, Keikoa Enomoto attended several commission meetings to request that undivided interest lessees from Maui would be offered any available lot in the future, and the commission agreed to that. Jumping the wait list, beneficiaries are concerned that people who secure an undivided interest lease could come from people below them on the list, thereby allowing them to jump the list. And then finally, location. The beneficiaries were also concerned about being locked into a specific location with no opportunities to choose at a later date. So some of the recommendations, the concept of the UI lease was to provide those longest on the list to secure an opportunity to transfer their lease to their successor. With the loss of several kupuna who have been on the list for more than 30 years, it is a loss that can never be restored. And the recommendation is that the new Kuhio Lease Award be offered to the first 500 people on the respective wait list, thereby removing the concern that people can jump the list and ending the long wait. For location of lots available, there are 2 recommendations. One is to provide Kuhio lease awards in areas currently in the development phase. Awardees can choose what area they would like to obtain a lot, and they would have a finite timeline to prepare for the acceptance of a lot, or they can wait for another preferred area. Communication with the department will be crucial to ensure that lessees understand the difference between an existing development and any future developments. The issue of blood quantum requirements have come before the commission before. However, the presentation made by the department into the commission meeting in April caused a measure of concern. The staff presentation on the history of how lots are awarded since 1960 is most accurate. Conversations with lessees in our oldest communities clearly tell how the department dealt with the issue of compliance with the Hawaiian Homes Commission Act's reference to the blood quantum requirement. And as new information comes forward, rules change, the verification of quantum also changes. However, the graph presented at the commission meeting is quite disturbing in that the department is requesting that approximately 112 applicants from 1960 to present be removed from the wait list due to lack of sufficient quantum. New information, new policies, and new processes being developed applied to applications decades old is unfair. This has been an ongoing issue and a challenge for applicants since quantum is re-verified with each new homestead development. And to be told after waiting for 20 years that you are no longer qualified due to new information being made available is a slap in the face of each beneficiary on the list, and is part of the reason why beneficiaries have a difficult time maintaining an amicable relationship with their trust agency. Using new information and policies to review older applications is unacceptable. For the commission, I would request that before the department embarks on this egregious action, that the commission be given full access to the written policies and operational process that is used to approve quantum certification at the time of approval, and that once certification is provided, there will be no further requirement to re-verify the quantum. Application of any new policy or procedure should be in writing with a detailed description and justification for any decision and recommendations being made, and should only be applied to applicants going forward. The other thing that I wanted to address, Mr. Chair, is that I noticed that this issue is on the current agenda, and we didn't get it until Thursday. But this is the second time now that this issue comes before the commission under a separate cover, which then prohibits us beneficiaries from getting more information prior to the meeting to be able to testify more cohesively on it. And so for issues of such importance, I think it's important that the department make every effort to make sure that the submittal is included in the packet. Regarding our compliance and enforcement activities, as noted in my previous testimony presented last month, I want to take this time to reiterate the need for planning and development of a compliance and enforcement division within the department. Rules and statutes that govern the Department of Hawaiian Homelands have no remedy to complaints and challenges without a compliance and enforcement arm in place. So once again, commissioners, I ask that you direct the department in investing time and funding to begin the process to make this happen. Regarding our resource management activities, as the work in the update of the department's general plan continues to move forward, I would once again ask the commission to be mindful of our precious resources on our trust lands. It is imperative that the department and the commission keep in mind the need and desire to protect these precious resources for the present and future beneficiaries of the trust. In closing, Mr. Chair, mahalo once again for making this opportunity available.
Mahalo, Blossom. And agenda item C8 is deferred till next month, likely if we have the submission ready. So I will open it up for commissioners to ask questions at this point. Randy?
Yes, so I wanted to start, Blossom, by thanking you for the amount of time that went into drafting this agenda submittal. It covers a lot of ground, and I think it makes a lot of really important points on a number of issues that we all need to think about. And some of it is such that it's probably going to require a separate forum for us to take a deeper dive into some of what's here. I do want to speak a little bit about the blood quantum issue, that I'm in agreement that that's an issue that we continue to look at very, very carefully. In regards to the submittal that you're referring to, I think I would summarize my concern this way, that if the department is coming before us to make a determination about whether or not we should disqualify people from being on the wait list, or in some cases, removing them from a lease as a result of blood quantum issues, it's very important that the commission be provided specific information as to why they have arrived at those decisions. So I think that's something that we should be given. And I would agree that something of this significance should not come to us undercover. I think it would be fair to both our beneficiaries as well as the commission to at least have a few days notice to review and look at what's coming before us today, so that everybody has a chance to think about what kinds of questions they may want to ask. So I think you raise another good point, resource management activities in our more remote areas that have forest reserves, areas that require a different kind of attention, but lands that are still under our jurisdiction. I do think that bringing this up for discussion is important. I know that the department has a lot on their plate, far more than they have resources to address all of the fires that are burning, but I'm glad you brought that up just for us to think about. And of course, the enforcement issues regarding challenges that our beneficiaries face on a daily basis across the state. I'm grateful to the department that they, through NAHASDA, they're setting aside some money to at least begin, at least making an effort to address that. We're a long way from becoming what we need to be, but I appreciate any kind of effort in moving forward on that issue. That's all. Thank you.
Thank you, Randy. Other commissioners, questions for Blossom? I don't see any hands up. Blossom, once again, thank you for continuing to bring these issues to the forefront. We will take very serious about the need for adequate notice with regards to any actions taken on folks on the wait list or any changes to Native Hawaiian qualifications. Mahalo, be safe.
You too. Thank you, Mr. Chair. Thank you, commissioners. Aloha.
Aloha. We have Kekoa back there. Okay, Kekoa. Agenda item J1.
Aloha, commissioners. This is Kikoa Inamoto from Maui, but I'm on Lanai today for a day trip, so I'm advocating from Lanai Island, Lanai City. And I'm representing the Maui Lanai Mokupuni Council, which is on behalf of 18 homesteads and homestead associations on 2 islands, and also on behalf of Pa'upena Community Development Corporation, which is headquartered in Upcountry Maui. So today I want to begin by thanking the commission for several things. First, for approving the 2-year due diligence right of entry to 127 Waiahuli Keokea acres, trust land acres in Upcountry in August of 2019. And Commissioner Ka'apu had asked for periodic updates on the due diligence. So on May 8th of an archaeologist, we took an archaeologist there, and she did an initial drive-through, which she called a windshield survey. And she's going to be returning on June 5 with an archaeologist from Oahu. And they're going to be doing the last two steps of the due diligence, which are a walkthrough, literature review, walkthrough. There's one step, and then a GIS mapping is the second step. So shortly after that, Pa'upena Community Development Corporation will be applying for a long-term license to that tract. Secondly, I wanted to thank the commission because they approved a grant that went to Kekula Nui o Waimanalo, and we're Pa'upena is partnering with them, and we're bringing courtesy of the department's grant, we're bringing 10 aquaponic systems to Maui families, and the first workshop to train our homesteaders on aquaponics will be held at the end of this month on May 3-day weekend, May 28th. And third, I wanted to thank and give kudos to Andrew Choi, the program manager of the planning office for the department. I really want to salute him for his support of our homesteaders at Ahunui and Molokai, so that they can have access to water. And he approved giving Pa'upena the raw data from the recent, there was a recent beneficiary survey, and that is to help us, Pa'upena, complete an Enterprise Community Partners Community Needs Assessment grant project. We received $50,000 from HUD to do that. And so Andrew approved us accessing the raw data that he acquired during the DHHL survey. And lastly, I want to note that the planning office did approve $250,000 for an EIS for Keokea farm lots. So I just wanted to really extend that mahalo to him and to the commission. So this past Thursday, we held the Maui Lanai Mokupuni Council monthly meeting. There were 19 participants. It was a Zoom session. And the result of that meeting were on agendized item 8C8, which concerns the blood quantum qualification to receive a homestead lot. Well, first of all, the packet said that the information about that particular agendized item is under separate covers, so we don't know exactly what that's going to be about, but Blossom Faytera attended the meeting, and she will be speaking more about that in her agenda testimony. But the consensus of all 19 members was that if our beneficiaries are going to be disqualified because they qualified under previous rules, but now the department is asking them to qualify under later rules, then the people who attended that meeting, there was a consensus they were against the disqualification of those 100 allegedly 112 waitlist beneficiaries. And the other item I wanted to bring up from the Mokupuni Council meeting was there was general consensus in favor of the Kuhia Awards program, which would give all of our homesteaders a lease immediately. There was general consensus support for the Kuleana program, which would put our people on the land as soon as possible. And the last thing I want to talk about is this coming Saturday, Pa'upena is sponsoring Maui Centennial Puvalu. It is the 7th in a series of 10 Puvalu that we held beginning last year. And the speakers will be on, the first speaker will be on diversity, equity, and inclusion in Hawaiian homesteading. And the second speaker, the president of the Kahikinui Hawaiian Homestead Association, will be speaking on her success in getting funding for homestead projects. And then the last part of that Puvalu meeting will be, we're going to be addressing the community needs assessment grant project with interactive survey questions. So I did send an invitation out to all of the commissioners, but I wanted to reiterate my invitation to everyone to join the Puvalu this coming Saturday. Thank you, Commissioner Ayla.
Thank you, Kikoa. Commissioners, questions for Kikoa?
Kikoa, just a few comments. I also wanted to thank you for taking the time to put together your J agenda submittal and for updating us on all of the activities that are connected to the Mokopuni Council. And other than that, I have no comments, but I do appreciate all of the information that was transmitted over to us today. Thank you.
Okay,
Thank you,
Randy.
Commissioner Awo. Mahalo.
David?
Thank you, Kikoa, for your report, and thank you for the update on the Paupena Community Development Corporation. I appreciate hearing the updates on what is happening, and it sounds like, you know, you're progressing. Well, I would be really interested to see what the archaeologists finds, if anything, in that area. But yeah, I appreciate you bringing that forward to the commission. Thank you.
Thank you. Thank you, Commissioner Ka'apu. Appreciate your comment. Mahalo.
Mahalo, David. Any other commissioners? Comments, questions for Kikoa?
And I thank you, Commissioner Kahanamoku, for RSVPing for the Puvalu. And again, I want to invite everyone to the Puvalu from 9 to 11 this Saturday. And I did email out the link to you all. Mahalo.
Okay, seeing no other questions. Thank you very, very much, Kikoa.
Thank you,
Next
Commissioner. Mahalo. Aloha.
Aloha.
Awiho.
Thank you. Aloha.
Aloha.
Next agenda item is J3, Rufina Agliam. Okay, aloha. Can you hear us? You appear to be muted. Aloha, Rufina. Can you? There you go. Okay. Aloha.
You hear me?
You're on.
Okay, aloha. It is my kuleana today to you on behalf of my mother, the late Fanny Mailani Agliam, and her 16-acre homestead on Molokai. I really didn't want to bring my personal situation to this meeting, but I realized I needed to make sure that my voice did not go unheard for myself, for my mother, and for other homesteaders who might face the same thing. After being a strong woman for 74 years, in July 2020, my mom found out that she had breast and liver cancer that has spread also to her kidney and her bones. After one round of chemo, we took her home to take care of her until her next treatment. She took 3 rounds of chemo before stopping treatments and ultimately giving in to the disease. The doctor gave her 6 months to live. When we brought her home, we started to make arrangements to care for her and get her all her things together. While my mom was slowly dying from cancer, we tried to contact DHHL and Molokai to check on who was her beneficiary for her homestead, which is 1 acre residential and 15 ag. That was when the secretary there discovered my mom had filled out her beneficiary application wrong. And although she checked the box for residential and agriculture, the tax map number she added did not include the number for the ag lot. A simple technicality, but a severe outcome. The secretary at DHHL, Molokai, Cindy, was the one that assisted my with the filled the form out with full intention, both that were check marked to my brother Albert. I tried to remedy the situation by getting the forms refiled. My mom was still alive by having her call into the office. But with the health problems and COVID, we weren't able to take my mom into the office. We asked Cindy if someone could come to our house and meet with us, but we were told that she wasn't sure if my mom was in her right state of mind and wouldn't come to do it. But at that time, I believe without a doubt, she was in her right state of mind and someone should have come immediately to rectify that simple mistake that was made on her forms before she died. But now because of this, her 15 acres of ag land will be up for public notice and we each will need to file claims toward her land. But we shouldn't have to be dishonored like this over a simple technicality that could have and should have been rectified immediately by staff. Today marks exactly 8 months since she died. The doctor said my mom had 6 months to live, but she died only 2 months after finding out. After she died, my oldest brother, who was on as the sole beneficiary, was told that he needed to provide documentation for our Hawaiian lineage by providing a birth certificate for my great-grandfather, Moses Makaivi Jr., born in 1896, or a letter stating that there is no official record of his birth in order to take over the lease as beneficiary for her residential lot. Yet it clearly states in the DHHL homesteader packet that your great-grandparents' documentation may be needed if applicable, and that's if your grandparents were born after 1920. We did find a marriage certificate, but DHHL guidelines state that the secondary documentation is only used after the letter that there is no official birth certificate is submitted. But my great-grandfather was one of the first homesteaders in Ho'olehua who helped prepare the way for future homesteaders by providing the Hawaiians, by proving that Hawaiians could live sustainably on this aina. In 1925, the county agent for the Hawaiian Homes Commission went to Maui to recruit families to go on the homestead, to go and homestead on Molokai. At that, the homesteads at Ho'olehua were not doing very well, and the homesteaders didn't have enough water. When he went to Maui, he went to see my great-great-grandfather, Moses Makaivi Sr., who the people of Waikapu knew very well for their ability to live off the land. Seeing his abilities, they strongly encouraged him to leave Waikapu and go to Molokai to help the homesteaders succeed. They brought over their entire ohana and gathered enough food for 3 years. The success of the Makaivi family and other homesteaders helped to establish credibility in the Hawaiian Homes program and prove that Hawaiians could still live off the land and they could work the land into productivity. Yet here I am standing before you 3 generations, 100 years later, being forced to provide legal documentation to prove authenticity of his Hawaiian bloodline. I tried to ask other ohana for the document, but had no luck. So to comply for a birth certificate, how long that might take. Hundreds of homesteaders are tied to this line. Yet it's strange how with everyone else that came from this line, no one has this document in their files or had been previously asked to provide this document. DHHL has been real inconsistent and shady with the situation. And it's important for me to tell you that my kuleana as I stand here today is to make sure that my ohana's homestead remains in my ohana, just as much as it is your kuleana to make sure Kanaka Maoli and people like me, the descendants of the original pioneers of Ho'olehua, never lose the land of our ancestors. In a DHHL report from the Investigative Committee on Native Hawaiian Qualification Process dated August 2020, it stated that the Act, however, does not provide guidance about who is Native Hawaiian and therefore eligible for a lease. Genealogy research can be very complex, with some documentation being hard to find, read, or both. Some historical records have been by fire or natural disasters. Sometimes people self-report different information over time, and vital records can even vary over time. Any of these factors can make documentation for a bloodline difficult. To compile such circumstance can result in uncertain or exhausted documentation, leaving potential beneficiaries in a limbo-like situation and department staff in judgment and discretion that the committee believes is beyond administrative function. So I don't blame Cindy for anything because she is put into situations where her judgment and discretion is beyond her administrative function. But I want to tell you and let you know that I will find every paper that you need for every person that I have to and jump every hurdle you place in front of me as I do right by my parents. And it is DHHL's kuleana to do right by the beneficiaries and have their best interests at heart. We are to be provided adequate amounts of water and infrastructure, financial support, and technical assistance. But I believe now there needs to be more assistance in genealogical documentation. We don't need help with loans or water if we cannot even qualify by proving that we are Hawaiian. We need more transparency with DHHL, and they need to feel like they are supporting me in proving my Hawaiian lineage instead of feeling like they are trying to prove that I am not Hawaiian. It's been an emotional struggle already losing my mom, but being threatened with losing her aina, the aina my parents farmed and worked so hard on to provide for me and my ohana, that has been worse. Losing it would be generations of future heartache. I do not like public speaking at all, but my passion moves me to break my fears of public speaking that have silenced me for too long. My passion also moves me to do more genealogy and motivates me to help other Hawaiians to handle their kuleana and honor our ancestors by making sure we know where we came from and record our genealogy so that the homesteaders are never forced or bullied off of our land, especially by those who are put there to help us Hawaiians, and especially in already difficult times when dealing with the loss of a loved one. I ask you today to remember who you stand for and what you stand for. Remember my mom, Fanny Mailani Agliam, and all the rest of the beneficiaries who have passed, who have ohana that are stressed and have to fight to keep their land. I stand here for all of them. Mahalo for your time. Eo.
Mahalo, Rufina. I'll go to commissioners for questions. Zachary?
Sure. Yeah, thank you. Rufina, thank you for your outstanding testimony. Really was very impressive. But, you know, Chair, is there any way the Homestead Service can be present at this time, or do we have to wait? I need to ask a question from Juan if possible.
Juan has come to the table, so I'll allow you to ask your question.
Thank you.
Go ahead.
Oh yeah, Juan, thank you, Juan.
Hello,
Yeah,
Commissioner.
yeah, thank you. You know, I've heard about this issue prior to today's meeting, and I read her testimony in the agenda. But because it's a technicality, I don't know if it's an error or just a technicality issue. Is there any way we can somehow overlook that and move forward for this particular family to keep their, so they don't have to go through the strenuous process of proving that they're Native Hawaiian, you know, because you know, it's just unfortunate that what had happened to Mrs. Agliam, but you know, it's just one of those things, and I'm you know, I'm just I just need some answers.
Thank you, Commissioner. First of all, I'd like to thank Rufina for taking the time to show up this morning and articulating your very private matter. I'm committed to helping you and the family to keep the two leases, the residential and the agricultural lot in the Ohana, keep it with the Ohana, subject to the rules and guidelines that the department must follow with respect to the successorship. So I will be in touch with you, Rufina, and I'll look at the facts of the case and see what we can do to, again, assist your family to go through this process that we need to follow or conform with the act and the rules.
Thank you very much.
Okay, Zach. David,
you.
did you have a question? No, no, okay,
Sure.
okay. Randy?
So, Rufina, mahalo nui for your testimony today. Juan, thank you for your willingness to offer kokua to her. But I think when I listen to this kind of testimony, it goes to the heart of why the Blood Quantum Committee was established, because whether intentional or inadvertent, there are inconsistencies historically within the department that lead to recommendations to remove waitlisters or cancel leases. So this is why I think it's important when these matters come before the commission, especially that matters that are requesting we remove a waitlister or we cancel a lease as a result of blood quantum, that the department provide us with documentation so we can understand the process that went into that decision that they are bringing before us. So it's probably going to be a very cumbersome process, but I don't think this is something that we should just rubber stamp without knowing the reasons why it comes before us. So that's all I have. Thank you.
Okay, thank you,
Mahalo.
Randy. Other commissioners? Dennis?
Oliver Fina for your presentation today. These are those kind of things that there's a lot of questions need to be answered. And we'll hope that the department can put together a package to sort of explain the steps that happen throughout this process. It's our responsibility to make sure we keep our homesteaders on the land. And also it's important that we follow whatever process was in place at the time. One thing I can offer is your great-grandfather is my wife's great-granduncle.
Wow.
She is she's a member of LDS and she does background work. So if I can get your information, I will have my wife look through our records. We were looking through some records the other day and found your mom and the granduncle. So you know, we're committed, personally committed, and committed as commission to ensure we take care of our lands. And we will ensure the department does a good job. There are sometimes, like you say, they're overwhelmed. And that's why we have a commission. So thank you for your presentation. And if I get your contact information through Leah, and then we'll contact you and see if we can do some genealogy work for that certificate you need.
That sounds good. Thank you so much.
You're welcome.
Mahalo, Dennis. Rufina, there are times when, of course, decision-making at the staff level is not possible. This is the
Yes.
process that you've brought it forward. There's going to be more investigation by the department, which will then make a recommendation to the commission. The commission has the ultimate authority to make some calls when the issue is not clear. So that's the process. Thank you for bringing the J agenda item forward. We will be in touch.
Mahalo.
Okay, if there are no further questions, then we will go into a 5-minute break to get ready for executive session. Okay.
Follow Rufina.
Thank you.
Mahalo.
Thank you, Rufina.
Thank you, Juan.
Thank you,
Thanks, Juan.
Commissioner.
Thank you, guys. Thank you.
Okay, so we are recessed. This session pursuant to section 92-5 subsection A, subsection 4 HRS to consult with its attorney on questions and issues pertaining to the commission's powers, duties, privileges, immunities, and liabilities. May I have a motion?
So move.
Second.
Okay, all those in favor say aye.
Right.
Aye.
Aye. Anyone opposed? No one opposed, motion carries. Okay, and then I believe we have Mel. us to bring everybody back into the virtual room. And then we'll do agenda item C4 first and then HSD afterwards. Let me know when you have everybody back in.
Birdies are going to join us.
Are they in?
Can you, they've been watching. You see them?
Yeah.
Yeah. Okay.
All right, okay, we're back in regular session. The next agenda item is agenda item C4. Joby?
Good afternoon, Commissioners. Joby Masagatani, Executive Assistant, presenting item C4. I have with me Tudi Purdy, Cami Purdy, and Kilia Purdy, the Ohana associated with this submittal. So without further ado, what I'd like to do is just walk the commissioners through the submittal and then allow time for the Purdy Ohana to add any additional information, perhaps before we open it up to discussion and questions. I do want to acknowledge Commissioner Helm and his very steady and consistent advocacy to make sure that this made it onto the agenda. So just want to mahalo him. So without further ado, some of you may be familiar with Mr. Purdy. He has been coming to the commission for quite a number of years with his request for additional acreage. Essentially, he resides on a 5-acre, it's an older lot, so it is a residence agricultural lot. That's the actual term for the lot, number 106. It was at one time part of a larger 40-acre lot. And if you go into the exhibits, Exhibit A identifies the lot as it originally was, as 40 acres. Exhibit B is the TMKs associated with the lot. So there are actually 3 different TMKs that are associated with the lot. TMK 31 is the 5 acres. 79 is the portion of the 35 acres that is can be cultivated, and then there's a 7-acre, approximately 7-acre gulch in this 40-acre altogether lot. And then it's Exhibit C kind of shows it as the attachment. This is actually the attachment to the existing lease amendment that kind of shows it more clearly in terms of the breakdown of the 5-acre or the different TMKs to this lot. So Mr. Purdy has been, since receiving the lot in May of 1980 as a transfer, has been working the lot. It is a primary source of income for his family, and inspecting the lot as recently as March of 2020, right before the February, March of 2020. You know, they definitely are working to expand their operations, have made improvements. The macadamia trees that are there are maintained. And so I think, you know, he is definitely doing everything that the department expects of a lessee in terms of an ag and in compliance with his lease. So he has been requesting the additional detached 35-acre to be added to his agricultural lot. I've outlined for the commission, but really for the record, the history of this lot, and essentially want to highlight on page 2 how this lot came to be 2 different lots. And that happened in December 12th of 1966, when the lessee transferred her lease, number 106, to her son, Frank Kupau. At that time, the 35-acre lot it's right next to the 5-acre, but considered a detached agricultural lot that was under a pineapple agreement with looking at the notes,
CPC.
with California Packing Corporation. And so at that particular time, what would happen is that the commission would take back the detached ag and offer it to the next individual on the agricultural waiting list. So at that time in 1966, Mrs. Evan English was the next applicant on the agricultural waiting list. And thereafter, the lot became 2 separate covered under two separate leases. One was to Mr. Frank Kupau, and the detached 35 acres was to Mrs. Evan English, because there was this pineapple agreement, which provided a source of income to lessees at the time. Subsequent to that, Mr. Kupau, when you look at the record, had some challenges with maintaining the conditions of the lease. He sought having the lease returned to the commission on a couple of occasions. And so in 1980, the residence ag lot was transferred to Mr. Purdy, who was held an agricultural lease at the time of the residence lot transfer, which is discussed further in the submittal as agricultural lease number 69E. In January 28th, 1977, by then pineapple, I think, had gone out of Molokai. The lot was not in cultivation. It no longer was providing a source of income to Mrs. Evan English, and she chose to surrender the lot to the Department of Hawaiian Homelands. And since that time, the lot has been in our inventory because there are definitely infrastructure challenges, one being access to the lot because there is no clear access, and two being no clear water infrastructure that's to service the back lot. So it's remained in our inventory since that time. Following around that same period of time, Mr. Purdy started to request from the department the opportunity to have the lot either exchanged. So he would receive lot 4B, which it's called 4B because it's just easier to refer to it that way, although that's not the official designation of the detached agricultural lot. But one option that he had asked the department to consider was to swap 4B, which is behind his residence homestead, for his agricultural lot that he was still holding. But the department deemed that that was not a swap, that was a surrender of an existing ag lot and an award of a new agricultural lot or of additional acreage to an existing lessee. And when we started to talk about an award of additional acreage, then our rules kick into place, which require that we honor the waiting list and provide the opportunity to any applicant that is not an existing lessee or married to a lessee. And so this challenge has been kind of in place since the very first request that Mr. Purdy made back in 1990. And he has been a strong and consistent advocate for his request. But unfortunately, and commission, the record does show that the commission did struggle with this on several occasions, but this challenge of how to award the additional acreage in the context of our existing rules kept everything kind of stuck. So coming forward, the options that were provided to Mr. Purdy was to consider a general lease, and what was provided to him instead was a revocable permit. He wasn't as interested in a general lease for understandable reasons. So a revocable permit right of entry was issued to Mr. Purdy. He was paying what was then the market price for that, which is over $200. And in 2015, the one relief that the commission could provide to the Purdys was to reduce the cost of this revocable permit to what he would have paid had it been a homestead lease. And thereafter, the price for this revocable permit went from $250 approximately dollars to $1.
Just to chime in, it was $437 a year.
$437, okay, to
Sorry.
a dollar per year. So in looking at this matter, the last time that they came before the commission requested that the staff look at what options existed, principally what it would take to amend the administrative rules. And so Hokule and I started to look at that option, which is outlined starts on page 4 of the submittal, or I'm sorry, starts on page 3 of the submittal, in which we discuss the specific rules that affect the award of additional acreage. And then on page 4, it identifies pros and other considerations of amending the existing the administrative rules. Primarily, the biggest issue of amending the administrative rules that the commission needs to consider is that we would really need to understand, and basically the rule that the staff is recommending would have to be looked at is providing the commission the discretion to award additional acreage to an existing lessee in circumstances when the properties are landlocked. So staff recommends that the commission, if it looks at this option, really needs to consider and weigh a couple of things. Number one, you're talking about revising a rule that affects the entire program to address the specific and unique circumstances of one lessee. So we would need to really understand and vet how extensive the impact would be of this rule change. The other really important consideration is the commission would need to really identify why the benefit of providing this additional acreage to an existing lessee outweighs the benefit of the opportunity to provide an award of a lot to an individual that's been on the waiting list and is not a lessee. So that's one option, is to amend the existing agricultural rules, or excuse me, additional administrative rules related to the request for additional acreage. The second option, which is the option that staff is recommending and has been discussed with the parties, offers a potential win-win opportunity. And that is to reconsolidate the two sections of the lot, Lot 4A and Lot 4B, and re-subdivide the lot. So you end up with a subsistence ag lot and the remaining acreage going to the parties still under lot lease number 106. So in this situation, a subsistence ag lot is no more than 3 acres. It would allow for us to have access to that lot that works, in collaboration with the parties, and so that it doesn't adversely impact, let's say, the existing macadamia nut grove severely, or the infrastructure that's currently in place. So the configuration of the lots, we would need to work with the parties as to what that would look like, but it would provide access to this subsistence ag lot, and then the remaining acreage would then be provided to this existing lot 4 or 4A. So that the consequence of that would be the party lot would go up to about 37 acres, and then the remaining 3 acres would be available to this new lot 4B that would be made possibly available for award to the next applicant on the waiting list when infrastructure resources are made available to upgrade the lot appropriately. One reason why we're looking at only a subsistence ag lot of 3 acres is because with a subsistence ag lot, all that's required is occupancy. You don't need to cultivate. And so if we were to award anything above that, there is a requirement to have 2/3 cultivation in place. And if I were a lessee taking that lot and for some reason was not able to cultivate, it'd be very difficult for the department to go in and enforce the lease provisions of that when there's so many other lessees within Molokai who have much larger acreages and have held the leases for longer and are not cultivating for one reason or another. So with a 3-acre lot, once the infrastructure goes in, all that a family would need to do is utilize the lot or reside on the lot. And so the opportunity for compliance is a lot greater. And with the balance of that lot going to the parties, I think they've demonstrated that they're able to put that into cultivation and utilize a lot consistent with what was intended for an residential or an agricultural lot. I think that that's the main thing that I wanted to cover in this. If we wanted to bring it forward to the commission just to have a discussion, because we recognize that it is a little bit unusual, and we do expect there are other lessees that are in a similar circumstance, potentially. We know at least of one. So we do want to make sure the commission has an opportunity to recognize that, we anticipate that there may be other lessees who would be interested in a similar consideration in the future. And with that, I'll turn it over to Mr. Purdy and Ms. Purdy and Kilia to see if there's anything more that they wanted to add.
Aloha to the chair, Ayala, especially to Joby and our Molokai Commissioner, Zach Helm, for all the efforts they've done to get to this point. And to all the commissioners that's listening in, and hopefully they would see the picture a lot clearer after this discussion. We decided after we see the two options, the second option is exactly what is our intention. We want to follow that second option, which is to get 37 acres and have a second parcel into that 3-acre lot, and we would be willing to do whatever it takes to accomplish that. As long as we are able to have this land, because my sole business is farming, and with the 5 acres from 1990 that I requested more acreage, we still, are very limited with the revocable lease that we got on the property. We already planted over 200, maybe 300 trees on it already. So we are in that revocable lease area and utilizing that area. Once we can get it under my name, our family will continue this process and continue the business, because this is 100% my business. It's farming on Hawaiian homestead land, and I retail my products right out of the homestead itself. So we would appreciate all the help from the commissioners to see this through. If you guys have any questions, anything that might be something that someone has no knowledge of, we're willing to answer any questions pertaining to this issue.
If I can also just chime in, I wanted to, especially like my dad said, mahalo, Joby, especially for this thorough history and background of the past 30 years and beyond, from the very beginning of the award of this lease up into this point, and really made it very clear. I think we have some new commissioners since my dad has been coming before the commission since 1990, and always had some changeovers, and today especially seeing new faces. So I think her report really makes it clear where we've come from and where we're trying to go. And mahalo, Commissioner Helm, for advocating on our behalf, of all of our behalf on Molokai here. We hear you, we see you, and we mahalo you for all that you're doing.
Okay, thank you, the Purdy's. So commissioners, any questions?
Chair.
Go ahead, Zachary.
Yeah. First of all, I'd like to thank Joby for all the hard work. Joby and Hopule, they put the documentation down, and really excellent job. And the Purdy's for being so patient for the past 30 years. But there's always a light past the tunnel. So hopefully we're gonna hit the light soon for you. And if this decision that is made, and then that particular option that you guys preferred, that can be worked out, that's what the bottom line is. And as homesteaders, and I'm one of them, we do have a lot of compassion of what we do in our lives. And I know Turi is a farmer, and his ohana goes way back, just like my ohana. So, is there anything we can do to support farmers like Mr. Purdy and his ohana? That would be great. So, yeah, I just wanted to thank you guys for being so patient. Mahalo.
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 Mahalo, Zach. David?
Yeah, I'm gonna disagree. I think that Joby should have done this long time ago.
Oh
when she
my
was the
gosh.
chair.
Exactly.
Well, but we appreciate.
I don't know why it took so long, but
We
had black hair and less wrinkles.
I had hair. I had hair the last time. Anyway, so my question is,
Yes.
since this is for information only, is this going to be a submittal at some point?
Yes. Yes. So that will be the next step.
When will that next step happen?
If we can get it on the agenda next month, we will. There's the two steps that we need to take is one, I need to talk with LDD to see who on their staff is going to be able to staff it. And if there's any initial due diligence, and the Purdy's can help us with this in terms of like just getting, a better idea of the lot, and we won't necessarily have the configuration, but what it may take, at least to get the subdivision in place. And then the other thing, of course, is to work with the Purdy's as to the next steps. So there are some options that I'm looking at to ensure that it can be expedited. We don't want to lose the momentum on this situation. So if it's not next month, then it would be the month following in
But
July.
arguably, we could approve it subject to the other requirements.
Yes,
right?
absolutely. Yes.
Which is like providing the access, the consolidation resub.
Right.
But at least the action is taken so that it's moving
Yes.
in that direction. Okay.
Yes. Yeah.
All right, thank you.
That's a good idea.
Andy?
So, Joby, thank you for that presentation. It was really helpful. And I do want to say that I do appreciate the department coming up with a creative win-win situation to resolve this issue. And I think it's important because we have people that like the idea of farming, but not everybody is a farmer. So when we have families that demonstrate that they are actually farming and have been for many years, I think it's important that when confronted with these unique challenges, that the department come up with ways to support that effort. So that's my only manao. I'm really happy that we're at this point. So thank you for that. That's it. Thank you.
Okay, thank you, Randy. Dennis?
Thank you, Mr. Purdy, for your presentation, and all to the family. You fit the mold. You're a farmer, you have a successful farm. There's a lot of acreage out there that's not being farmed. We have the same problem here in Kauai. So for Joby, will we have some kind of at least a plot so we know exactly where these lines are going? I'm looking at Exhibit C, and it shows, a bunch of wiggly lines, but are we gonna have something a little more clear as to where access will be to Lot 4B and where the definitive lines are, property lines on this reconfiguration?
So I think it's a question of really for the commission, if we would like to move expeditiously in terms of at least getting the authority to the department to move forward on the specifics. We won't have, other than maybe a very conceptual diagram of what the lot configuration will look like ready before next month. Yeah, because we do.
Right, that's all I'm looking for, is something conceptual at this point, just so we know how you're gonna access 4B and where the property lines would be. Just some kind of a schematic. The other thing is on the subdivision costs, is the department picking up the cost to subdivide?
Yes, we would be picking up the cost to subdivide because we're looking at essentially, it's a cost we would have incurred anyway in order to secure the lot in the back.
And then my final question, because I like to move cautiously on some of these things. I understand the Purdy situation. They probably crossed all the Ts, dot all the Is, and they're the perfect candidate to allow this to happen. But we do have other, and right here in Kauai, we have property that's landlocked. And we have to make sure that it's clear that if you're going to assume some property or we're going to do that you do have a successful farm operation. You actually have a
Yes.
farm. You meet all the criteria. They meet all the criteria. I'm more concerned about how this is going to impact all of our homesteads throughout the islands. How many lots do we have landlocked? What kind of issues are we going to run into? So, before we make this kind of a decision on administrative rules, we want to know what the impact is going to be. That would be only my concern. I think this sort of fits the mold, but it could get moldy as we get to other islands.
I totally understand where you're coming from, Commissioner Neves, and I can say that having gone to see the Purdy homestead, as I said, in March of 2020, they actually are doing and in compliance with what they're supposed to do. And looking at their file over the last week, they've been responsible in terms of anytime they've borrowed money from the department to make improvements, those monies have been paid back. So I think from a textbook situation, or you couldn't find I believe a better example of a situation to say. And if there is going to be an opportunity that other lessees are interested in pursuing, absolutely being in compliance with your lease is going to have to be step one. So it may actually provide an opportunity for individuals that want a similar situation to address lease compliance issues that if not for this opportunity, you're kind of at battling with them to get to get back into compliance. So that's an opportunity potentially down the road. I did want to also mention that it is striking. I know that Tootie has said this to the commission before when he's presented, but it is striking when you go up there to see the homestead that, you get 40 acres and they're not in, no one's cultivating. And then you get to the Purdy MacNut and it's the only one that's cultivating in about, maybe 6 or 7 or 8 lots up there. So in any case, I definitely understand what you're saying, Commissioner Neves, about making sure that, lessees are in compliance before we start to look at these kind of very specific opportunities.
Thank you.
Joby, the current proposal does not require a rule change.
No.
Okay.
Option 2 would not require a rule change.
Thank you.
Okay, other questions, commissioners? All right. Seeing none, I want to thank the Purdys and thank Joby for this very creative solution. She has been working very hard at it. And say aloha, you folks. It'll get done. It's getting there. Okay.
Okay.
Mahalo.
Mahalo.
Mahalo, everybody. Hopefully we get this done.
Mahalo, Joby. Mahalo, commissioners.
Yeah.
And Chair Ayla.
Aloha.
Aloha.
Thank you.
Before we go to the rest of the agenda, I wanted to give an opportunity for commissioners to make comments on the public comment. Earlier, there was a request to take some time to review the public comments. So this is a good time to see if there are any questions or comments on the public.
So, William, if I could.
Yes.
So, I had a chance to read our Maui public testimony coming from Donna Sterling. And I wanted to acknowledge publicly receipt of her testimony. And part of that testimony was her having concerns about not being properly consulted as a separate association from that of Cook. And no, I don't have it in front of me now, but I think it was concerning the ungulate removal initiatives that are unfolding up there. So I just want to, in addition to acknowledging we have received it, in addition to summarizing for the record what she is concerned about, I also want to make a comment that we did meet on Sunday with Cook. Donna was present, and part of what was contained on the agenda was some of the concerns she has raised here. So I think I was able to clarify what the intent of the department is. And I did let Donna know that we start with acknowledging Cook as the officially recognized association that we work with. And as a result of continuing efforts to restore the forest that's within that enclosed area, that I encourage Donna and her association to participate in meetings with Cook to bring their ideas to the Cook table. And that's the venue upon which we can include them and others in our discussion. So I just wanted to indicate that for the record, and that's all I've done.
Okay, mahalo, Randy. In fact, the department did respond to a similar email from Donna with almost identical advice for her and for her new homestead association. So thank you. Any other commissioners, comments on public testimony? David?
Yeah, thank you, Chair. I want to address the email from Jojo Tanimoto. I don't see Kahana in the room.
He will be back for his agenda item. If you want to
Okay,
address
so
it.
maybe we can, I can save my comments till his presentation, because in speaking with him earlier, I think some of the issues that were raised by her are being addressed. And so I would like to let her know that those items are being addressed. So, okay, thank you.
Thank you, David. Other commissioners? Okay, don't see any hands. We will move to agenda item number D14, and I will just be informing all the commission members that I believe I have a conflict. Lurleen Isla is my auntie, so I will recuse myself from the vote.
Good afternoon, commissioners. D14 is to approve the final approval of the subdivision of the Department of Hawaiian Homeland's agricultural lease number 6677, lot number 4A-1-2, located in Waianae, Oahu, consisting of 4.5 acres, which has been subdivided into two lots, lots A and B. The commission granted a preliminary approval of the request to subdivide at the meeting on February 20th, 2018. And 3 years later, it's finally completed. The lessee has complied with all the conditions requested of the department, as well as the city and county of Honolulu. And on February 5th, 2021, city and county planning and permitting provided or granted the final subdivision of the lot.
Do I have a motion to
So
consider
moved.
staff recommendation?
Second.
David and Randy. Questions, commissioners?
Hey, I do.
David, I'm sorry.
Is that,
Patty first.
is that normal practice from the county? They take so long, yeah?
Unfortunately, yeah, the lessee experienced some requirements that was provided on a piecemeal basis. There were some other issues where signage, the street signage were stolen. So the department had to procure the signs installed before the county could go back and inspect. So there were some things that unfortunately the lessee needed to wait, because for one, the department again, the signage, there was an issue with the fire hydrant. As you can, if you reviewed the submittal, the configuration of the lot initially was different from the final subdivision only because the lessee, part of the requirement that the county imposed on the lessee was that there was a requirement of a fire hydrant that needed to be located within 350 feet of the entrance of the lot. And having to install a fire hydrant would have been the lessee's responsibility, which would have been expensive, but the lessee was fortunate that there was an existing fire hydrant on Helikahi, which resulted in the configuration of the lot to take advantage of that existing fire hydrant. But yes, Commissioner, the lessee had to jump through several hoops just to get to the point where we are today.
Yeah, I see that a lot. I just wanted to make mention, the county takes up such a long time, but also if you have to install a fire hydrant, that's another huge cost for the tenant. So, but thank you.
You're welcome, Commissioner. Thank you for the
Thank you,
question.
Patty, David.
Yes, thank you. So Juan, the process is for subdivision is you need to have county final approval on the subdivision before it's brought to the commission.
That's the process for the subdivisions of agricultural lot as well as pastoral lots. We come to the commission on those type of leases preliminarily to allow the lessee to go ahead and procure a surveyor, get all the requirements imposed by the county. Final approval by the respective counties will result in the issuance of the tax map key as well as approval of the final subdivision so that we can appropriately amend the lease with the approved plans by the respective county.
So a subdivision will come to the commission twice.
That's correct on agriculture and pastoral.
Okay, thank you.
Any other questions? Oh, go ahead, Russell.
Thanks, Chair. So one, it's noted that the effective date of the subdivided lease will relate back to the original preliminary approval from the commission. And I'm not opposed to that, but I'm just trying to understand why that is.
Well, the subdivision is approved by the commission. Once the approval is granted, the department will go ahead and draft the lease for the original lease 6677, which the lot description will change, which requires the amendment. And then we will issue the lessee's son Barnabas another lease for the respective lot. Again, just as a note, the commencement date of that newly created lease for the son, the commencement date will be the original commencement date of lease number 6677.
It'll be the date you obtain preliminary approval.
No, the commencement date of the newly created lease will be the same commencement date as the original lease. So the newly subdivided lot will not receive another 99 years. Hopefully I'm answering the question, Commissioner.
Oh, understood.
Oh, any further questions? Oh, Dennis.
Yeah, so as was mentioned, if they did have to put in a fire hydrant, would they come back to the department to put that fire hydrant in? Because the fire hydrant is now part of infrastructure. And it's on, if we give them the road, it's on county property. So if I put in a fire hydrant, I own it. Doesn't sound
No.
Yeah, if I gotta pay for it.
It don't work that way.
Yeah, the fire hydrant would still be located on the road.
Yes, I understand that, but who's gonna pay for it?
As the lessees are made aware of, any and all costs involved with the subdivision of the lot, any expense incurred will be passed on or will require the lessee to take care of the expense. And that was part of the preliminary approval. That's the condition that the department recommended, which the commission approved, that all expenses incurred and associated with the subdivision is the lessee's responsibility, including the cost of fire hydrant if one was needed.
Yeah, so I don't know when it was approved, but I sort of have an issue with that because now, I'm paying for a fire hydrant. Nobody else in the street paid for a fire hydrant. And the fire department's gonna use it. If something happens in a fire hydrant, am I liable because I paid for it?
Okay,
It's not
Dennis.
in public hand at that point. That's what I'm saying. I hate to bring these things up, but it can't come up down the road.
Yeah, Dennis,
Got
Stuart
hurt.
is here, so perhaps he can help answer your question.
Hello, Commissioners. Stuart Matsunaga, Acting Administrator, Land Development Division. Kalamai, I didn't introduce myself earlier. Just to maybe try to put some perspective on this. Okay, so this action, as I understand it, and we did work with HSD on this matter for a request to subdivide and transfer a portion of the lease. So in that case, what the rules provide for is that the lessee would incur all of the costs for the subdivision because they're transferring it to who they want to transfer to. In the case of let's say a lessee subdivides and leaves provides the department with the balance of the lot. And then we go through the process of awarding that new lot to the waiting list. Then in that case, DHHL would incur the cost of the fire hydrant to improve that lot to become awardable.
Got it. So
That's the difference that that we see in Land Development Division.
So Stuart, there's no, if I was subdividing a lot for one of my relatives or whatever, and I had to put in a fire hydrant, do I now own that fire hydrant, or do I have to release that fire hydrant back to the department for the infrastructure?
The fire hydrant becomes licensed to the Department of Water Supply as all of the other infrastructure is licensed.
Okay.
The other water infrastructure is licensed.
Yeah, and if I can jump in, Dennis, in fee simple land, if you want to, especially on the Big Island, if you're going to do a subdivision, for example, if you do a 4-lot subdivision, they make you put in a fire hydrant, they make you put in a turnaround lane for the fire trucks. They may require that you put a holding tank so there's sufficient water. All of that is at the cost of the homeowner and not the county. So I think this is similar in this situation where it's benefiting, it's a public benefit, right? For the department and for the neighbors and everybody, but you had to put it in because you wanted the subdivision. So
yeah. Okay, thanks. Thank you.
Okay, Malo.
Any other questions?
Yeah, Stuart.
Hi, Patty.
Hi, Stuart, but the hydrant, they're fortunate that they already have a fire hydrant. They didn't have to get a new one put in, but isn't that a county street adjacent to that property? It's the fire hydrant is currently on a county road, correct?
It's I believe it's DHHL land.
Oh, okay.
I'm not clear what level of maintenance is provided. If that was a street that was turned over by way of city council resolution to accept the improvements.
I see.
But I think what we
What
did,
Kolea Li'ili.
Oh,
so I
Vice Chair,
think,
if I could just clarify.
Sure.
So on Koli'i'i, there is no fire hydrant close enough. On Haleahi, which is the cross street, there is a fire hydrant close enough if they switch the configuration of the lot, and that's what happened.
oh, okay, okay. All right, thank you for the clarification. Thank you.
Any further questions?
Nope.
If not, it was moved and seconded. All in favor, say aye.
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 Any opposed?
One recusal.
And one recusal of Chair Ayla. The motion passes. Thank you.
Thank you, Stuart. Thank you, commissioners.
Thank you.
Vice Chair. Okay, next agenda item.
Next agenda item is D15, and there's three actions. First is to approve the cancellation of the late Alama K. Wellborn's tenant in common leasehold interest in residential lease number 10934, lot number 7 in Pio Honua, and to approve to dispense with the awarding of the decedent's tenant in common leasehold interest in the lease. And lastly, to approve Norman Kalima, the surviving tenant in common interest lessee, as the tenant by severalty for the remaining term of the lease. Norman was the original awardee of the lot. And upon receipt of the lease, he transferred the lease to himself and his sister, the decedent. So being that no one submitted a claim, it only makes sense to have him retain the entire lease rather than going to the list to award a one-half interest in the lease.
Thank you, Juan. Do I have a motion to consider staff recommendation?
So move.
second,
Questions, commission members? So it's pretty straightforward. Okay. There are no further questions. All those in favor say aye.
Aye.
Anyone opposed? Seeing none, the motion carries. D18.
D18 is a commission designation to approve the selection of Pumau Uopuna C. Garmin to succeed to the interest of Pearl U. Garmin to residential lease number 4899, lot number 25A1 in Kuhio Village on the Hawaii Island for the remaining term of the lease. And if Pu'umau does not execute the lease by July 31st, 2021, his successorship will automatically revoke to authorize the department to extend the deadline up to 30 days for good cause, and to declare if Pumau Opuna's selection as successor is revoked, then the lease shall resume its status as unleased Hawaiian homelands.
Okay, can I get a motion to consider staff recommendations?
So move.
Second.
Okay, all those in favor say aye. Oh, sorry. Questions?
Chair? Yeah,
Dennis and then David. Go ahead, Dennis.
okay. Yeah, I just wanted to, and I should have mentioned this at our last meeting, but I'm so thrilled to see that we're putting in actually deadlines. Because there's so many things just hanging out there. I appreciate that. One, I know that's something new we've seen over the last couple of meetings, but I forgot to mention that. Because we've got stuff out there for years waiting for somebody to get back with paperwork. And it's nice to see that deadline in there, and you got a 30-day if you don't do that, and it goes back on the list, and I appreciate that. Thank you very much.
I'm sorry, that was 16.
That was 60, yes.
Yeah, you're
You don't have 16.
Yeah, you don't.
It's not
I
on the agenda.
apologize.
It's not on the agenda. But
This
that's,
is a clarification. That's agenda item D16.
D16, I'm sorry, I apologize,
That's all
my
right.
bad.
Okay.
No, we got so many this month, I'm getting
Yeah.
lost.
all good.
D16 was approved under the consent. Thank you, Chair.
Yep.
Okay.
I apologize for that.
So many
This,
mistakes.
Yeah. Oh, my goodness. Yeah.
We are done with that.
Yeah, that was approved
Do you have a
earlier.
question?
Yeah, I'm just gonna beat the dead horse
Yeah.
again.
D18.
Okay, let me see here.
One eight
Yeah.
and Dennis, this is the one that you indicated that you were.
You're
Yeah, we still, well, okay,
We're
we
on
did
D18.
the 18 or 16?
He's done.
D16, we already approved. My bad, Commissioner. That was under the
Yes,
consent
yeah.
agenda. So it was
Okay.
approved earlier. I was reading the wrong submittal.
I see, yeah, I was missing. Okay, yeah, I recused myself from D18.
That's okay. We're back on track.
So we are now on D18 and I will go slow. Oh, boy. D18 is to approve a request for a third-party agreement for agricultural lease number 6567, lot number 10, situated on Anahola, Kauai, for Alvin Gu.
We have a. Yeah, so we have a motion to consider staff recommendation for D18.
So move.
Second.
Thank you. Discussion, questions?
Chair,
Yes?
Yeah.
Zach?
yeah. Juan, how big is this lot?
It's 3 acres.
Okay, 3 acres. Okay, thank you.
I don't think Mr. Nevis can talk during this time, Chair.
I can't. It's public comment. I'm voting on anything.
Oh, man, we don't have that. I apologize. It's
Oh.
3 acres. It's 3 acres.
Oh, my God.
It doesn't have
Another-
size of the land. That's why I asked. I don't see it anywhere.
You're right.
We will improve the subdivision.
Yes.
David?
I want to know what we know about this third party that I know very little about his ability to farm.
We may need to go in the exec session for that.
What are we planting on this land?
I don't know.
It's not part of the submittal, so we will move on. Any further questions? Okay, if there are no further questions, all those in favor say aye. Aye. Anyone opposed? Seeing none with the recusal of Commissioner Nevis. Thank you.
Thank you, commissioners. Thank you for the laughs.
He was testing me here, I think. Okay. Johanna's not here. Let's go to G1. Andrew is here and he's ready to go.
Andrew's always ready.
I'm glad I appeared that. Aloha Commissioners, Andrew Choi, Acting Planning Program Manager. Item G1, that the Hawaiian Homes Commission issue a finding of no significant impact declaration based on the final environmental assessment for the DHL Anahola Kuleana Settlement Plan, District of Kauai, Kauai, PMK 448002001, 003, 006, and 447002004.
Thank you, Andrew. Do we have a motion to consider staff recommendation?
So moved.
Second.
Proceed.
Commissioners, Planning Office presented this submittal last month for information only today, we are asking for the commission's action on the recommendation. If you have any further questions, I'm happy to go through the PowerPoint, but if there are none, I can. Did you folks want me to go through the PowerPoint real fast, or it's?
Any commissioners want to go through the PowerPoint? Okay, hearing none. If any commissioners have any further questions? Okay, all those in favor say aye.
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 Anyone opposed? Seeing none, the motion is carried. And then we might as well finish G2 since you're here.
Okay. Item G2, that the Hawaiian Homes Commission approve an amendment to the Kauai Island Plan that was adopted in 2004 to apply subsistence agriculture, supplemental agriculture, pastoral homestead, community use, and special district land use designations to Anohola, Kauai, Kauai TMKs, the same TMKs I said before. Commissioners, this would amend the Kauai Island Plan to be consistent with the Anohola Kuleana Settlement Plan Final Environmental Assessment.
Thank you, Andrew. Do I have a motion to consider staff recommendation?
So moved.
Second.
Okay. All those in favor say aye.
Aye.
Aye. Anyone opposed? Seeing none, the motion carries. Thank you very, very much, Andrew. Thank you.
Yeah, Andrew.
Good, Andrew.
Okay, we're gonna bring Kahana up for agenda item F1. All right, welcome back.
Aloha and good afternoon, Commissioners. Kahana Alvino, Acting Administrator, Land Management Division. Land Management Division has one submittal agenda item, item number F1. Again, this is the annual renewal of right of entries for the North and West Hawaii Island.
Okay, do we have a motion to consider staff recommendation?
So moved.
Second.
Okay.
The motion again is to that the Hawaiian Homes Commission approves the following actions while developing a process. Again, that process is still ongoing. I know I'm working with OCH to procure a vendor to help us with the process in making agriculture and pastoral lands dispositions available to beneficiaries under items A, B, and C.
Commissioners, questions for Kahana?
Yeah, I have a question. Kana, do you know when we'll actually be start to put these out under the new RP program? Do we have a ballpark?
Like I had mentioned, we're working with, I'm working with Joby and trying to procure a vendor and helping us put it together kind of thing. And we hope to get it off soon.
Okay.
And just to of note on this right of entry, on this specific submittal, we have one right of entry permittee who passed and we had canceled that permit. Also to further note, the permittees who are non-beneficiaries, I did, LMD did increase their rent by 3%, their annual rent. We have a total of, go ahead.
Which ones were non-beneficiaries? I couldn't figure that out.
What is that again?
Who are the non-beneficiaries on this list?
Hopefully you guys can see it. It's highlighted in gray. Anyway, the first one entered.
I see.
Yeah. So you see on your table.
Yeah.
Okay, so in this case, quite a few are beneficiaries, which is, acceptable. Just that we'd like to know when the rest of the program is going to get on. But one other question, and that is, you note in here a lot of insufficient infrastructure. What type of infrastructure for what type of business? Maybe a little more clarification would help. No, I don't need it now, but maybe next time you go around, if you like. I noticed it said on the first one, it's commercial. It says insufficient structure. I just want to know maybe what kind of business they're doing. They don't have a fence, or you know what I mean? Just to give us a better idea of what insufficient structure means for us.
Okay.
All right, thank you.
David?
Yeah, thank you, Kana. on Polycoki Ranch, what's the status of that? Because I understand that that is part of what Kailapa is trying to deal with in doing the fencing, but are they still actively ranching?
To my knowledge, they are still actively ranching. I know the land is getting bare because of the goat issue. I know they're paying their rent. They haven't fallen back on that. And I know Woody Ramos has expressed some concern because of the dryness, because of the illegal trespassers that are going up there. So we look to work with, working with them. As I had mentioned, we're working still on the fencing issue.
Is there a house on this property?
I'd have to double check on that.
Yeah, I don't know the answer,
Yeah.
but I was just wondering if there was, 'cause this is an ROE.
Correct.
Okay, thank you. And then I had a question about the submittal, the email from Jojo Tanimoto about, can you tell me what the status is regarding the fence going up to the water tank?
Yep. Again, I think I shared earlier, we just procured a contractor for that, and just recently. I know we've been going through that process. Unfortunately, it didn't work out in the earlier request for quotes. But we just finished one, like I said, recently within the last week. We have a contractor that is selected, and we're going to work with them in installing that fence line. Of course, we still need to work on some of those legal matters regarding the trespassers. So that's where we at with that.
Okay. And there was one more item. Okay, so that takes care of the water tank issue. Her other opposition was to the Kohala Center for doing the fence, and she said that the fence was not high enough for that the goats were still able to jump over that.
Okay, so that's a matter that I'd have to work with Kuli and address that.
Okay.
And he's working with Kohala Ranch on that fencing matter.
Okay. So, and then on the rent for Polycoki, that's still, is that going up 3% as well, or?
That one, I did increase that one too.
It's still the same.
Yeah, it's still the same. Because that was a general lease way back in 2011 and it expired, we decided to keep them because they were a sublease on the Kahua Ranch on that bottom portion of that land. Kahua retained the top portion, and we agreed to work with Polycoki to keep that bottom section, all keeping that same rent that they had at that time, the same. Yeah.
Okay. And then my last question is regarding the 381 acres to Parker Ranch. I guess the Kahua Ranch and Parker Ranch. Kahua Ranch, I understand the infrastructure issues. I still wish that we could put that into community pasture. But for Parker Ranch, that's just above Malama Solomon's lot. But do we own the land that's between Malama and this 381 acres, or is that owned by somebody else?
I'd have to double check that. I can double check and get back to you on that. If it's landlocked, if it's,
right,
two
that
separate parcels.
I was wondering if that was the issue, because it seems to fit a pastoral, and we did I know Malama has a pasture land that's community use, right? We rent that to her. And so if we could get somebody on, or if we can put the 381 acres into community pasture, because there's so many people on the Big Island that are asking, right, to put cattle somewhere. It would be helpful, because I have no problem taking it away from Parker Ranch.
Parker Ranch, right. And the only issue there, I think, is the adjacent land, the access to that property. That's if it's way up there on the top.
Yeah, it looks like there's a gap between Malama's lot and then this 381 acres. And I just don't know what the access is to
Okay.
that. Yeah, yeah. So maybe we can circle back on that.
Yep.
some other time. Okay, thank you.
Russell?
Thank you. Kahana, I had a question about your exhibit B. So you attached the Collier's report and you reference it in your write-up.
Yep.
You basically use it to say, if I'm reading this correctly, that given COVID and the current state of the market, it doesn't justify increasing rental rates. However, we're gonna still increase the rate for non-beneficiaries. Is that-
Yes,
that-
correct.
So in the normal course, do we typically do that across the board for all the ROEs when we renew them? We are raising rates based upon market information for non-beneficiaries, but the beneficiaries typically stay flat, or I'm trying to understand how we.
Yeah, basically, I mean, this is one where, I just felt that we needed to increase some of the the non-beneficiary rental terms. And I guess it's a year by year kind of analysis where we look at whether to increase our beneficiary side.
Do the beneficiaries and the non-beneficiaries at the inception of their lease of their ROEs, are they given the same rates to start off with? You know what I mean? If we don't give
Yes.
special consideration to a beneficiary when they enter into a lease,
No, they're all the same, pretty much.
but we give a special consideration to a beneficiary status when we renew the ROEs.
Correct.
Okay, and that's like that's a position the department has taken. Kind
Yeah,
of consistently.
that's the recommendation that we're putting forward.
Okay, and then my other question was the cancellation for the ROE. I guess the person passed away.
Yep.
What's the process for getting that marketed and back out on the market, and how quickly is that typical turnaround to get that back out and generating revenue?
Again, we got to go through this process. It's basically getting if we want to get a market rate, if we're going to do an appraisal, I mean, that's going to cost us money, or are we going to go by tax assessed value? Typically, right of entries or revocable permits, what we used to call before, we went through the tax assessed value, which we get through the counties. So that's where we build off market cap rate of 8%. And what I remember was from the 8%, we'd take it down to even half of that because of the infrastructure, of the access, of the type of arrangement they have, a month to month. They cannot do any permanent type of improvements to the property. Again, like I said, it's a month to month type of disposition. They cannot get any financing on that.
Well, I guess I was asking, what is the process when a ROE is canceled and we have a property available for ROE to put it back out on the market? Is there some timeline, or is it just depends upon what? That's what I'm trying to-
Timeline and requests, I guess. Requests for properties.
Do we have a list of people who have indicated interest in the various ROE properties to work off
we
of?
do.
Okay.
Russell, in this particular case, the ROE passed away. There is, the ROE was utilizing the property for an overflow parking for their restaurant that is next door to ours. So in the interim, the plan is to reach out to whoever is the successor to the restaurant and to continue on a temporary basis so that we continue to generate revenue. And then
Okay.
we can take a look at the long-term disposition of this property if there's a demand for it.
And then in the meantime, we just allow the the parking while we try and figure out a deal with the operator?
No, while we try to figure out if it makes sense to put it out for someone else to bid on it so that we can get more revenue.
Okay. And what's the typical turnaround for something like that? Is it just varies depending upon, you know, I know you guys get plenty to do, but I'm just trying to figure out if is it supposed to go back out on the market within X amount of days or?
I'm thinking of working with the current successor of that restaurant to retain that continued rent. And eventually, if we can get more rent for a different type of use, again, this is a small area for overflow parking. Access is a little bit of a challenge from the main highway. And this tenant has access immediately from the highway to their restaurant, which goes behind their restaurant up to the parking area for the overflow parking.
Okay.
So I mean,
It's not, I've only seen it once or twice. I'll defer to David if does it look like an attractive piece of land that somebody might be interested in?
I think it's attractive, but we would have to create an access to
Correct.
the highway. So we own all the way down to the Akone Puli,
yes,
right?
yes.
So if we put
But it
an
goes up.
access road there, I guess because there used to be the old Doi store, right? I think that's on our land, right? The old Doi store.
I don't remember. Yeah.
If we made an access there, I think it would be attractive to develop it and maybe general lease it because it sits up higher. And so people would have a view of the harbor and so.
And Chair, that's a good discussion to have. Mine was more a procedural thing. I wasn't asking about this specific property, but more when a property is canceled for whatever reason and it becomes available, is there a procedure that is followed or a timeline that is try to follow regarding putting it back out on the market, or is it just kind of ad hoc? We do, and I know everybody is overworked and not enough time to focus on everything, but I'm just trying to figure out what the.
Again, it's built off of requests, Commissioner Kopu. Basically, if we garner enough requests, 1, 2, maybe 3 requests, I could bring it out to the commission to authorize a general lease to move forward with a general lease kind of thing.
Yeah.
Or an auction, correct.
Okay, got it. Thank you.
We're also open for suggestions. So, you have certain expertise. We'd be interested in hearing from you. But right now it's all on an ad hoc. And then as you can see, the property we're discussing, there is an option of bringing a road. We'd have to calculate how much it's going to cost. And then we'd have to see what an appraisal is going to cost. And then to see if there's somebody that will do it at that price point.
And of course, if we general lease, I mean, we got to think of the environmental assessment stuff, due diligence and all of that things too, yeah.
I have question.
Yes, go ahead, Patty.
Hi, Kahana, thank you.
How's it?
I just wanted to educate myself here. What does community use mean on their rental? They're renting it out to the community, or is that what?
So it's a community use type project where people from the community can use the site, whatever they're using the site for. Say, for example, okay, I'm trying to think of a community use type. Keokaha, we have our Pane'ewa Hawaiian Homelands Community Association. I think Keokaha Pane'ewa Farmers Association has a community use parcel where they do farmers market type thing.
At no charge, it's just for the community?
No, they are charged. They are charged $20 a month, $240 a year. And that's for beneficiaries type thing, yeah.
Oh, that's great. Okay, thank you.
Okay, thank you, Patty. Any other questions? Commissioners? Okay, seeing none. All those in favor say aye.
Aye.
Aye. Anyone opposed? Seeing no opposition,
Mahalo.
the motion carries. Thank you.
Thanks, Hannah.
Continuing on the agenda, legislative update. Perfect timing, you walked in the door. Lehua.
Aloha, Commissioners. Lehua Kinilau Kano, Legislative Analyst. This is just for information only to summarize the legislative session. In terms of the state budget, the legislature ultimately decreased the governor's operating funds request for DHHL of 15.9 million to 14.7 million in general funds for each fiscal year. But the plus side is the legislature allowed DHHL to maintain its position count at 200 positions. But some of those positions have no funding allocated. With regard to the governor's CIP request of 20 million for lot development and 5 million for R&M for existing infrastructure each fiscal year, the legislature appropriated 30 million in fiscal year 2022 and 20 million in fiscal year 23 for lot development and 5 million for R&M for existing infrastructure each fiscal year. The legislature also appropriated CIP funding of 17 million for Pulehunui improvements and infrastructure and 1 million for land acquisition on Oahu of particular TMKs in fiscal year 22. So I tried to provide charts so that it's simpler to review in terms of what was DHHL's sufficient sums request, and then what was included in the governor's budget, and then what came out in terms of funding for both the operating and the CIP. So that's the state budget. In terms of legislative proposals, we went in, the commission approved 14 legislative proposals to be included in the governor's package. Following this approval, the legislative proposals were reviewed by the Attorney General's office and the governor's office, and 7 were included in the administration's legislative package. 2 of those 7 proposals were enacted into law. It's the school impact fees legislation that would exclude housing developed by the department from school impact fees, but it does have a 3-year sunset date on that legislation. And the second bill is largely in response to the commission wanting to expedite contested case hearings, especially for certain types of activity. Although I couldn't get the legislation that would have identified criminal or those kind of related activity, what the legislature did move forward was to allow contested case hearings to be conducted through use of interactive conference technology. And that would take effect October 1st, 2021. Again, it would be a method to allow the commission to move quicker on particular matters. In terms of concurrent resolutions, I just wanted the commission to be aware that there were 4 concurrent resolutions that passed. 1, establishing a working group to assess the status of Act 14. The second one, requesting DHHL in conjunction with the County of Hawaii Department of Water Supply to provide a progress report regarding the development of the Ka'u water system. The third one, requesting Congress to consent to the enactment of Act 80. That one has to do with reducing the blood quantum for successors to 1/32. And finally, it would allow for a working group to be convened to develop recommendations for implementing the Revitalizing Economy and Agriculture Leadership Initiative. So those are 4 actions that would need to take place between now and the next legislative session.
Questions, commissioners?
Thank you, Chair. What is the effect of a concurrent resolution?
So a concurrent resolution is that both the Senate and the House passed it. And so it does impress upon the department to complete those actions. Sometimes only a Senate resolution or only a House resolution passes. And then those, the department has more discretion. So a concurrent resolution is pretty much the legislature informing the department to implement these working groups or these actions.
But it's not like, does it have the force of law, or is that just their strong recommendation? In other words, if we didn't do it, what would happen?
So typically, so just to give you an idea, concurrent resolutions are often used what the auditor's office uses to conduct audits. If you just pass a resolution, oftentimes the auditor's office does not move forward with those recommendations. So, I would articulate that it is law and we should implement versus if it was just a single resolution, we have more discretion in that regard.
Okay, thank you.
It relates legislative intent. So I think one of the consequences would be if we chose to not do it for any reason, whether or not we had time or resources. Likely the following year, you would see a law directing us to do something.
Right. So all of these resolutions, are they clear enough so that we understand what should be done? I mean, do they articulate specifically, milestones that have to be reached? And you know what I mean? Because, for example, County of Hawaii and us doing something on the water system in Kau that's been sitting there since World War II. I don't know what we're supposed to do. You know what I mean? So there's no funding that goes with it. They just tell you, go work it out. I don't know what they expect.
Well, that one is just a progress report. So both Land Development Division and Planning Office are aware, and there's a June 30 deadline on that. So as long as we provide our report to the legislature, at that point, it's whether or not the County of Hawaii is also going to provide what is required. I know that the chair of the Water and Land Committee in the House has indicated his interest in wanting to work with the counties and the department to address some of these issues. So I think it'll have implications over time, both Water and Land. So the House Water and Land and the Senate Water Land Chair, they're both Hawaii Island legislators. So, I think they have taken a keen interest in anything that's going to impact Hawaii Island.
So when we give our progress report, would we then be trying to set up the next step, which is to get funding for, actually implementing the water line?
Yeah, it's our opportunity to request additional funds. So in the case of Kau, we have enough to finish a segment. So the next ask would be to finish the next segment down further. So it provides that. As far as Act 80, it's simply, we will, the legislature's indicated that they want Congress to consent. We pass it on to DOI. It's up to our congressionals to pick it up or not to pick it up.
And we've already gotten an indication from DOI that this requires
in
Congress's
this specific one, it was in the act that passed that it would require consent of Congress.
The agriculture one, I'm not sure because it may be useful in terms of making recommendations for the next legislative session. Act 14 is one that's a little bit more challenging for us because, portions of Act 14 settlement is part of a lawsuit. So depending, we'll let the attorneys figure out what we can discuss and what we can't discuss in terms of the task force and what they're set out to do.
Yeah, so all of these come with their own kind of set of challenges. And so that's why I was wondering, what are we supposed to do with it? You know what I mean? So, okay, but I appreciate it. Thank you.
Try to address it as best we can, right?
Halehua, I have. Halehua. Thank you, Mr. Chair. So Lehua, is it feasible to say that the legislative budget to FY23, the CIPs that the department put in was not cut, but the vacancies money for the vacancy positions was not put in? Did I hear that correctly?
Yeah, so on the attachment, so that you're talking on the operating side, if you'll see our sufficient sums request was 50 million. The governor had put in 15.9 in his budget, and then the legislature reduced that dollar amount. But you see the position counts, they kept the position counts. So we basically were able to keep positions, but they're unfunded.
You're unfunded. So they're unfunded for FY through 2023. Is that correct?
Yes, they could go in next legislative session and make adjustments and add funds in, depending on how we do in the economic recovery. Again, I think the upside for us is that they didn't cut positions because it's harder to get those positions back. And then on the CIP side, separately, As you can see, we did significantly well in the first year. Obviously, still less than what we've asked for substantially, but it is pretty much double the governor's ask in year one. And then year two is consistent with the governor's ask. And they could always decide if they want to supplement those CIP funds in the next budget. So.
Okay, great, thank you. Hopefully they don't touch the CIP funds so we can see all of our projects move forward. Thank you, Mr. Chair.
Just make an observation, Patty. The two money chairs are from Maui. So of course, the additional funds went to Maui. Again, yes. But we have our ask in it, so we do have a little bit of discretion, although not much in terms of how to apply the CIP.
Okay, well, Mr. Alvo, mahalo for Maui.
Russell?
Yeah, Chair, I want to ask both you and Lehua, if you guys could give a layman's grade to how you think things came out on the budget side and then on the legislative proposal side. And when I say grade, I think your guys' effort is beyond question. I think, A for effort for the entire department for working through this mess of legislative and gubernatorial relations. But where do we end up? I mean, we talk about good and bad and this and that, but where are we? What's the general summary for us?
I think on the budget side, we did really well. And what I'll put into context is, you got to remember they were talking about furloughs at one time. There was a bill to sweep funds from our general funds, would have took like $19 million from our admin account, 23 million from the special bond fund. So overall, none of those funds were cut. We got positions in place. We didn't get, again, 14 versus 15 million, I think is really good. We did really well on the CIP side. So I would say on the budget, we did really well, especially when you look at other departments. Some other departments, they had monies moved out of their department to another department. There's just
what is your school grade? What is very well, like a B+ or a A- or
on the budget? I probably would say we were probably in the A, B+ to. I mean, again, we would have loved to get the full amount, but I think the compromise was we didn't get positions cut because the governor would have cut positions, but we got less than what the governor asked. So I would say, I think we did better because we kept those positions, even though they're not funded for right now. So I would say, yeah, maybe like about a B+ on the budget side. On the legislative package, that's very typical. I mean, there's thousands of bills that get introduced every year, and on average, a very small number of them get passed. We did really well. At least we got school impact fees. Obviously, we would prefer it without a sunset date, but we can always go back in and try to repeal the sunset date. The remote contested case hearing, I think that was good as well. It'll give the commission more flexibility. The downside was, I think we would have got the GE exemption, but because of the American Rescue Plan, and there was a provision in there that if there's any kind of cuts on any kind of exemptions, then you'd have to reduce the funds that you're getting from the federal government. So that's why that bill got held up, because that one was moving along until that happened. That would have been a really good additional piece of legislation had it not been for the American Rescue Plan Act. Aside from that, I think there's issues we need to work with the new chairs. There's new water land chairs, as I said, some of the water issues, and I'm thankful for Andrew and Jonathan. They worked really hard. I think there's a lot of education that needs to take place about our issues that these these chairs are newer as new chairs, and they're saying they're committed to working in the interim. So we'll see how that conversation goes. The other area, I think, besides water, was probably where we struggled the most, and I don't know if it's a disappointment or not, was the Board of Agriculture giving us representation on the Board of Agriculture was moving along for most of session. And then when it came time for the floor vote, the measure failed in the Senate. And I know the chairs of the committees were in shock with the failure. I know the Department of Agriculture has some concerns. So to the extent that we can address some of the concerns, but we need to think about, do we really want to have representation on these boards, or do we just want to try and have working relationships with these departments? So I think on the legislative proposal side, it's hard to say. I would probably, given that we got 2, that's still pretty good. But, you know, there were other measures that I think we could have got. But again, I'm just taking it that these are newer chairs. Another chair I think we have to work on some education is with the chair of housing, our infrastructure bill, where we wanted to have the counties. I think we got stuck there a little bit. But sometimes you have to look at, is legislative proposal the way at addressing the issue? If we can work directly with the county and now have a better relationship, say with the city and county of Honolulu, and maybe have those issues addressed without legislation, there's always that opportunity as well. So letter grade, I would give that one more like somewhere between a B and a C. I don't know how you would take the gaming bill. I think obviously it created a splash at the legislature. Some of the other staff told me I kept it interesting by having that at the ledge, but I really think it helped in the conversation on our budget. I don't know if we would have done so well on our budget because they couldn't criticize us that we came to the table with a proposal. Whether you liked it or not was another conversation, but at least we brought a revenue generator to the table. I think it made a difference. You know, I don't know if we would have fared as well on the budget without that proposal, because we were one of the agencies that came to the table with a proposal, whether you liked it or not. It was a proposal.
Okay.
Then if you have a different.
Well, I was just say it allowed us to highlight the need side and the requirement side from both the legislative responsibility for sufficient sum. So it did, I would agree, it did help us in terms of the final numbers in the budget. It, you know, caused consternation amongst ourselves, but I think discussion is good, and discussion in the beneficiary world was good. I would say a C. I would give a C overall grade, both on the budget and on the CIP and on the legislative actions.
Okay.
But a C in this environment is pretty good, I would say. There was, when we started the year, it was grim. It was really, really grim. If not for the American, well, if not for the various packages that came through Congress, I would say we'd be here today and there would be further layoffs and we'd be trying to figure out how to keep lights on and any number of those things. And that's what the discussion was early in the legislative session. The GE would have been really, really nice, but as one of the consequences of the American Rescue Plan, you couldn't reduce any taxes. So the GE was poised, our GE exemption was poised to go, but then at the last minute, as those federal funds came in with their sort of restrictions, the legislature had to back off on our GE tax.
Okay.
It's something that I think we made the case for later on when federal funds don't impact, you know, the reduction of taxes for us. I think we can go back and get a win there. So the preparation was really, really good.
Okay.
Thank you for asking.
No, thank you. Yeah, I appreciate, and again, I appreciate all the effort. I had a question for you, Chair. I know it wasn't part of our package, but this legislation regarding the extension of leases on state lands, I read the release, and I know that, you know, basically it wasn't part of our package. We weren't pushing it, but I wanted to know more how that affects us since it
I would answer your question this way. It depends on what the Department of Interior, as they do their analysis, comes up whether or not we need consent of Congress. Our position might be very different from theirs. And then we'll see how the differences of opinion might get worked out. I've been cautioned by Ryan that, if things are unclear, then any extensions that would be granted would be, suspect. So I think we need to tread lightly. I do plan to have we plan to have some soft conversations with DOI. We currently have, is it 228? Yep. So 228 allows us to extend our leases for up to 20 years. But DOI opined that needed this consent of Congress because there was no what would you describe it? No alternative on the DLNR side. Well, now the DLNR side has 40 years and ours is 20. So it's still not parity yet. So as we get more into the discussions about how to apply, providing the governor signs it, then we can come back and inform the commission of how it's going to fit together if it gets to that point.
Okay. Yeah.
How it could help us is we have, for example, I think it's the Prince Kuhio Shopping Center that is very much interested in putting in some significant improvements for that additional extension. But again, understanding that some of our beneficiaries may oppose an extension like that because they would prefer to see it come back and then be able to bid it out, and they bid on it again. So I guess to be determined is the answer to your question.
Yeah, so at the right time, Chair, maybe could I suggest maybe a workshop on that legislation?
Sure. Once we know the governor's going to sign it or allow it to become law without his signature, and then getting the answer from the Department of Interior, or maybe inviting the Department of Interior to come here and brief us about what they think. That might be a better one. Okay.
Okay. Thank you,
Mike.
Thank you, Chair. My first question, I think you answered. I wanted to ask what influence, if any, the federal funding have on the success of our budget. And I think you mentioned that if it wasn't for, like the whatever the 2021 Rescue America Act and whatnot, then the budget wouldn't be as favorable as it resulted in. Is that a correct statement?
I think that's a correct statement, not just for our department, but for all of the departments. Across. There was a $4 billion deficit that was being looked at, and governor was serious about layoffs. Governor was serious about
furloughs and whatnot.
Furloughs and all of those things. And it wasn't until the money started flowing in from the feds that they were able to take a look at not doing as drastic or taking as drastic measures.
So, okay, that confirms. But having said that, then it's all because of the pandemic, right? I mean, the majority of the support from the federal government. So
that and I believe to get the economy going. I mean, it's a combination.
Right. So are we looking ahead as to the next fiscal year, or is it too early to be thinking of that?
Watching the revenues come back slowly. I think all the Council on Revenues have been projecting the numbers that they calculated 6 months ago. The new numbers are much more optimistic, but it's the general sort of thought process is still going to take 5-6 years in order to fully recover, right? But you see the tourism numbers coming back. It's like 75% of the pre-COVID time.
Right.
That makes some people happy because they go back to work, but it makes other people less happy because they got used to not sharing the beaches with tourists, so.
Yeah, yeah. And my last comment, I just wanted to just state, I support doing a workshop, yeah, on that House Bill 499, the one to increase the lease by 40 years.
Okay,
The
as soon
one
as we have,
that Russell,
as
yeah,
soon
the one that
as soon
Russell
as,
said.
as soon as we have more information as to what the governor is going to do and what DOI is going to say, then we certainly will bring it to the commission.
Okay, thank you.
Any other questions? David,
Has anything changed at the DOI
in
as
terms
far
of,
as personnel? We have the same,
we have the same
same
three,
people here?
yes. I think what has changed is sort of the management at the top, right? So I think the management at the top is more friendly to indigenous people as it was under the previous administration. So hopefully we'll see those kinds of changes percolate downward, and we get more favorable opinions from the Department of Interior.
So this is off the subject, but there was that whole push for them to do the surveys.
Yes.
Is that done? Have we got a
The land
report?
surveys are continuing. I think COVID sort of put it on hold, but they're starting it back up again. So Nanakuli, I think the surveys have started back up again in Nanakuli.
And has there been any discrepancies between?
Not reported as of yet, but they didn't get very far. So that's, again, remains to be seen.
Reported earlier, the Senate confirmation of Congresswoman Deb Haaland to be U.S. Interior Secretary makes her the first ever Native.
Oh, he's got a live call going. Okay.
Yeah, thank you.
Thank you. There are no other questions? Thank you. We'll move on to C6. There we go. Boku, it's nice to see you in person. But that ice cream
no ice cream
background.
in the back.
Yeah.
Aloha Commissioners, Hokule Lindsay, Administrative Rules Officer for the department. And this is item C6. It's just an update on the administrative rules for supplemental dwelling units. And really the purpose of this is kind of to refresh your memories. We're coming up for our planned public hearing at the end of June. And so I thought it would be good to just jog your memories again. We have the public notice will be published before you meet again. So I thought this was the good meeting to do, even though it is quite a ways ahead of the public hearing. So just a little bit of background, again, to refresh your memories. The SDU is what we're calling it for shorthand, but it's a supplemental dwelling unit. It's essentially an Ohana unit on the Big Island, or an additional dwelling unit for Maui County, Kauai County, and the city and county of Honolulu. It's smaller than the primary dwelling, has its separate entry, its own kitchen, bedroom, and bathroom, and it can be attached or detached. And for now, we're looking at a 5-year pilot for qualified residential lessees. With 3 years into the pilot program, the rules do require that the department evaluate the program, come up with any recommendations to improve the program or to extend the program. But it gives us that opportunity to take a look at what's working and what's not working. We're basically working with 3 parts, right? The lessee, the lot, and the unit itself. Again, residential lots is what we're looking at. The lessee would need to get county approvals and permits. So the lot has to meet all of the county requirements. The lessee themselves must be in good standing. Once they have the unit, they would need to comply with housing laws, and the lessee must reside on the lot. So one of the things is the SDU can be used as a rental unit or an Ohana residence. And we just want to be clear that the requirement for the lessee to reside on the lot does not change, even though they can rent out space. The rental, if the lessee chooses to use the SDU as a rental, must be to a native Hawaiian as defined by the Hawaiian Homes Commission Act. And that comes from the act in section 2085. It allows rental to another native Hawaiian. We also have the Ohana use kind of track, and that's to a qualified relative of the lessee. And we're just piggybacking on section 209A of the act that identifies the 25% relatives that are qualified to succeed the lease. So we're piggybacking on that definition. So it can be a 25% spouse, children, grandchildren, or siblings of the lessee that can live in the unit and contribute to household expenses. But we're trying to make a distinction between rental and use. And then the other important thing is no short-term rentals. The lease term must be at least 6 months in length. So far, we started this process in 2018, and we did beneficiary consultation. The report was accepted also in 2018, and then we got approval for public hearing in 2019. You may remember our update in October 2020. We had discussions with the counties about some of their processes and how it would impact our beneficiaries. All of these submittals can be found on the website. And this is one of the things we're trying to be better about in order to get information out before the public hearing. So we have a dedicated page. The submittals are up on that page. We have a short video that's almost ready to go up on the page as well. And then we'll update that page when the public notice comes out and as the public hearings proceed. The next slide is just, again, a reminder of what our process looks like. We're almost at the end. Once we have the public hearing, we can finalize the draft, and then assuming everything looks good to you folks, you can adopt the rules, and then we'll forward that for governor's approval. So what's next? The public hearing is going to be virtual at the end of June. It'll be live streamed. People can sign up to participate live, so they can give their testimony live, or they can watch it live streamed, or they can watch it after the hearing itself has happened, because it'll be recorded and then available at a later date. We're also planning to send out a postcard, again, try to open up communication a little bit more with beneficiaries so people know what's going on with what we're doing. But I think with this in particular, it's a good topic for us to, a particularly good topic for us to move on that, because we do have quite a bit of inquiries about building additional units from both beneficiaries as well as the district offices in trying to manage those requests and how to respond. So again, everything is on the website. The rules, the draft proposal is up there, and updates on our process is also available on the website.
Thank you, Hoku. Questions for commissioners?
Your chair.
Yeah, go ahead, Zach.
So this is a pilot program, right? So,
Yes.
And how many years is that pilot program going to be?
So it's slated for 5 years with a review after 3.
Okay. So what is, well, we'll have to wait after 3 years to know what's going to be like, right? To make a decision if it's going to be a permanent program, right?
Yeah.
Okay. Thank you.
Thank you, Zach. Any other commissioners, question?
And Chair, it's Dennis.
Dennis?
Yeah, so Okalei, just we had a short discussion our last meeting about complying with the rule on lodging. So the SDU, whether it be a separate dwelling or attached to the dwelling, here's a scenario. family has a 4-bedroom house, all the kids are gone. So now there's only 2 people in the house. If they modified their house to have a 1-bedroom with a kitchen and a bathroom, that would be covered under this SDU. Is that correct?
Yes.
Because it would be within, it would meet the qualification of having a bedroom, bathroom, and a kitchen. But they just have to modify their house. They'd be in the same house with a separate entry.
Right, so it can be attached or detached with that separate entry.
Yeah, so that sort of covers the renting lodging issue, and they still live on the property. So just wanted to
Yes,
clarify.
they still have to live on the property. And I think an extension of the question you're asking is the people that the lessee currently living in the large house, but would really rather downsize, can move into that smaller unit and rent the primary dwelling out instead.
Sure. Got it. Thank you.
Thank you, Dennis. Any other questions? Okay, I don't see any, so thank you very, very much. Hoku.
Thank you.
Thank you.
Thank you, Hoku.
Okay, the discussions on covenants. Are you doing it?
I think C7 is the DCCR conversation, which came under the C agenda, but I think Gigi is going to take the lead on that.
All right. Thank you so much.
Aloha. Good afternoon, commissioners. Gigi Cairo with the Planning Office. This is item C7. Informational workshop, homesteads with DCCNRs. This is a continuation of our prior workshop back in March, where a question was raised. So we're coming back to follow up. So what I'll do is just give a really brief background, because I know you've heard me talk about this a lot. Just the basics on DCCR homesteads, and then we'll try quickly to get through the policy question at hand and spend most of the time with discussion. Next slide, please. So again, DCCRs, it is a real estate document called the Declaration of Covenants, Conditions, and Restrictions that are placed on the land. And the DCCR document itself is attached to every individual homestead lease for properties with DCCNRs. The second part of this is with the DCCRs, typically what's called a planned community association is established by the developer, or in our case, either the developer established it or we did, the department, as required by statute. So also required by statute, this particular type of association requires homeowners to automatically be members. Mandatory dues and assessments are charged to individual members. And of course, the DCCR document itself, with all its provisions, binds the homeowners. So Hawaiian Homes has 18 homesteads located statewide that have these DCCRs. There are no DCCR homesteads on Molokai. That's the only island we do not have any. Next slide. And again, just brief. We have a total of 18 homesteads. The department had created 12 homesteads with DCCRs, and the department acquired 6 properties, mostly from State Housing Finance Corporation. So those properties came with DCCNRs. They were pre-existing. Next slide. So, we've covered this before. There are key differences in the application of the DCCR model to homesteads. The department's initial approach was to take the existing DCCR model and apply it straight to the homestead developments without any adjustment to the needs of the homestead nor their geographic locations. So because of that, we didn't really make any adjustments. The implementation and our experience with these DCCR homesteads has been very, very mixed. And we've been running into many implementation challenges and unclarities. On the right-hand side, in fee simple world, typically the developer, develops the property, creates the association, and then when the homeowners completely move in, the association is transitioned to the homeowner association, and the developer is long gone. They no longer participate. In Hawaiian Homes, on the left-hand side, as both the landowner and the homeowners are lessees of ours, we are forever tied to these properties, to these developments, and that's a big major difference. And we need to account for that and figure out how to better support this model on the left side on Hawaiian homelands. Next slide. So at the March commission meeting, the question popped up about the new administrative rules that we are planning to roll out. And the question was about homesteads moving forward. So the basic question is, should the department require all future homestead developments to be established as DCCNRs, in which case then the new rules would automatically apply. So there were kind of a couple of basic areas that to support this policy question. One is, oh, no, back up, please. Sorry, I kind of lost my train of thought here. So one of the biggest items is we're attracted to this model because of the state statute requirement that every homeowner is a member of this association. So that would help clarify, who represents this association. Another factor supporting this question is that this will help associations to manage the properties and be kind of a coordinating entity to work with the department and the counties and law enforcement in regards to illegal activities such as gambling houses, cleanup such as junk cars, aesthetics of the homestead. And then the other thought was that if the department could provide a template of DCCNRs to address health and safety issues at a minimum, that too would help in stretching our resources and help building sort of a sense of kuleana within these homesteads to take care of their properties with a set of rules, with a set of consistent rules. So, as at staff level, as we've been, looking at this model for a long time and presenting information to you folks, this basic question still keeps popping up. Next slide, please. It's really function before form, right? You folks have heard from us before about the past, how this model was applied, the challenges, implementation challenges we've had. And, so we know about the past and we've had many lessons learned. But really for us, it kind of comes back to what really is the need? What are we trying to accomplish with this model? And is this the right model? So over time, this is kind of what we've heard And I think that's kind of where the discussion needs to start is really what's the function? What is it that we're after? Is it to identify a single entity that clearly represents a homestead? Is it to preserve the property value, ensure health and safety? Is it to empower the lessees to self-govern and self-manage the homestead? All of the above, and or are there other needs? And I think really until we really figure out what it is we're trying to accomplish and determine what is the best model or models, there might be multiple. The legal structure, the organizational shape will become more clear. Or other alternatives. So again, planned community associations, they are real estate development entities. They're not necessarily the entity to serve as the overall political or social voice representing the interests of a given community. Their function is to manage the property. Homestead communities are allowed by state law to organize themselves freely, and there can be and are multiple organizations serving the same homestead. So that's why I want to go back and pose this question of function before form. What are we trying to accomplish? And there are alternatives. If really the alternative is this concept of a single entity and self-governance, there are political subdivisions that could be established that have an elected body of the people, governed by the people. We've also been awaiting authorization to implement State Act 302, where there would be these entities called self-governing organizations. We're waiting on congressional consent on Act 302. The commission can also consider adopting its own criteria, defining, who is the single entity that would represent a homestead or homestead developments, in cluster. So there are many alternatives, and I think really it comes back to the question of, what are we trying to accomplish? Next slide. So if in fact we determine that DCCRs and planned community associations are the solution or one of the solutions, here would be some of the next steps. We really need, we need to prioritize the resource allocation to support these associations. We really have no dedicated staff, nor resources, financial assistance or otherwise, to support these associations to function. The department did not completely and thoroughly set them up properly. And since the beginning, they've really been in a bind to try to function, let alone, maintain their status as associations. At the department level, again, should we continue with these DCCRs, we need to have division roles and responsibilities and an operational plan and procedures. And in earlier discussions on trying to implement any administrative rules, there needs to be ongoing education and enforcement. Without the enforcement on the back end, the rules really don't have much much meaning. Now the department has made several attempts to work on education, but we have been sorely inconsistent. We would start a program, it would stop, it would start again. This is about the fourth time that I'm aware of that we're going back out to these DCCR homesteads to try to, again, raise awareness about what DCCRs are and to provide the information about the new rules. And of course, lastly, beneficiary consultation is always a good thing in involving our beneficiaries in discussions and gathering their input on, how do we move forward. Next slide. So yeah, I've used this slide before. It's just a reminder for all of us in any programmatic functions that the department undertakes, whether it's something new or where we're trying to improve an existing program, again, involve community throughout the process. We need to have an upfront research and analysis on the concept phase. Is this really the program, and is it structured correctly? And what are the cost benefits to the trust and the affordability to the beneficiaries? Then we can formulate the policy and propose a policy to you folks as commissioners. And then when it comes time to set up the program internally, we have to have an operational plan before we try to implement anything. And then, of course, the back end evaluation and adjustment of the policy and program as needed. Okay, I think that's it.
Thank you,
Mahalo,
Gigi.
commissioners.
Before we take questions, I'm gonna ask Commissioner Kaupu, excuse me, if you had any comments.
So thank you, Chair. And so that everybody else knows, I presented some thoughts for Chair and Gigi, which I see got incorporated into her presentation. And I think I'm probably credited with raising the question of whether going forward we would implement these type of homestead associations with DCCRs to govern homesteads going forward. And I'm generally in favor of doing that, but to clarify, I think that we can do that prospectively as we go forward and we do new homestead communities. And we set up the program and we set up the form of entity and we set up the game rules, and people are accepting leases into this new format, which provides some of the things that Gigi went through, including certainty for us. We know who we're dealing with. This morning we talked about Kahiki Nui, and there's two different associations, and I don't think I still question myself which one is the real one and which one is not the real one, or maybe they're both real ones and we're supposed to be dealing with both of them, but they obviously can't between them to get along. So it makes it difficult to as a commission and as the department to administer going forward. So I think if you look forward, as new communities come online, if the system is set up and is administered correctly, they're accepting leases into this new system, this new format, and they know how it works, and they're accepting a lease in that format. Going back and working with the existing associations and trying to get them on board, or trying to get those communities that don't have any DCCR or association presence and trying to get them on board. We certainly can do that, but I think that's a voluntary thing. Those are already, those communities and those organizations, if they're already set up, exist, and they have a presence, and the people in those neighborhoods already are working in a certain way. So I don't think we can dictate to them to change that. So my thought was prospectively, we have a consistent program that is spun out for each of the communities going forward. And again, for the reasons, it's consistency for the department and the commission. It puts right now, we spend a lot of money that was intended for developing homesteads to maintaining and health and safety type issues. I think those, the front line for those kind of issues should be in the communities and should be with the homestead associations that have members who are frankly paying assessments so that their community can stay safe and can stay attractive. And I wouldn't say so much about maintaining values. And I think that the types of rules and restrictions could be set up so that they're not over the top and too restrictive, like some other communities that try and restrict and govern things like the color of your house or the use of your parking space and all that kind of thing. I think there's limits if we stick to the health and safety stuff. No derelict vehicles, no gambling, no drug dealing, all that kind of thing. And then we allow the association to be the front line, to be the people who identify a problem, who go and keep records, and then reach out with the department to law enforcement and say, here's an established observation of illegal activity, that kind of thing. So Chair, I appreciate the opportunity to speak to the issue. And just to clarify, I'm in favor, but going forward, not dictating to what is existing out there now. Make it available, but not mandatory for the existing homesteads.
Okay, thank you, Russell. Other commissioners?
So I'm sorry, Chair. I wanted to mention two more things. It was in my write-up, but I just thought I'd verbalize it. So just from the beneficiary perspective, two other things that we mentioned. So in fee simple world, properties are available to any member of the public, and generally families, they look for a DCCR community, and they make that choice. For beneficiaries, their biggest motivation is they just want to get on the land. And even though there was the DCCRs, the earlier ones, homesteads, they were provided the documents and some information about what a DCCR is. Their overall motivation is to get on the land. And once they're there, their intent is to stay there for generations. So unlike in fee simple world, when a family moves into a planned community, they can choose to leave at any time. They can, choose to move somewhere else for whatever reason. For our families, it's unlikely, they're going to get up and move. Because again, the motivation is to get on the land and transfer their lease to their successors. So that's a big difference between our beneficiaries coming into a planned community. Secondly, in terms of moving forward, should all future homesteads use the DCCR model? Also keep in mind, I would also keep in mind the affordability. We have so many families who cannot qualify basic financing for the home. If these are all DCCRs, we're going to be adding homeowner dues, fees, assessments on top of an already strained household budget. So this may have an unintended impact of no alternative for those families that are on very limited household budgets. And those are the ones, I worry for, is we have so many families, who it's been hard just to qualify, to get a home. And then, we're going to lay on all these administrative burdens on them making it almost impossible to qualify. So those are just the two things I wanted to add. Thank you.
All right, thank you, Gigi. Randy?
Yes, I'm gonna try to parcel out what I think is, for me, is most important, and that is, I don't believe that communities should be mandated to have an association. I think that should remain a matter of choice. I think the concept of DCCNRs sound good. It creates an expectation that all communities will function at a certain standard across the board, when in fact, that's not true. In Hawaiian homes communities, what you see is, when you look at DCCNR communities, what you see is varying degrees of success as well as varying degrees of failure. What you also see is, even in high functioning DCCNR communities, when the department, and I see here, the part that I find a bit troubling. I understand the concept of believing that an association will assure that a neighborhood will maintain its aesthetics, but that's not true. It works for some and not for others. But the one that concerns me the most is when the department is saying this will help to ensure health and safety. And the way I interpret that is the creation of an association to give them the authority to self-govern also means that when criminal activity is occurring within the neighborhood, that they serve as the front line to mitigate that. And part of that mitigation, if it's about reporting, compiling information, associations have discovered that's extremely challenging and in fact at times dangerous. And when they are willing to take on that kuleana, they have to ultimately come to the department for assistance in order to get law enforcement to respond. And we know that that's just not feasible. And so going back to what Gigi said earlier, I think what she said was we have to have an operational plan in order to provide that level of support. And that plan does not exist, at least not at the capacity that's required to support associations moving forward, not just moving forward, but even today. You know, several months ago, I get a call from a high functioning Maui association that is saying the criminal activity occurring in certain parts of our neighborhood is beyond our capacity to manage it. So I don't want to see associations carrying that responsibility. So anyway, I'm going to end there, but that's my thoughts on that piece. Thank you.
Thank you, Randy. Other commissioners? Okay, we will continue to, I guess, mull on this one as we try to move forward something and improve the process. So Russell and Gigi, thank you so much for the work that you put into this. We'll go to agenda item G3 next.
Thank you, Chair. Thank you, Commissioners.
Thank you. And before going to G3, we'll take a 5-minute break. Sorry. Okay, recess 5 minutes. All right. You're done.
Yes.
Okay, welcome back, everybody. We're back in session and we're on agenda item G3. And I have with me at the table, Andrew.
Aloha, commissioners. In normal times, we would be in West Hawaii, but because of COVID-19, we are, for the most part, virtual. So this month, we are giving updates on West Hawaii water issues and also as well as plan implementation. So item G3 is an update on West Hawaii water issues. And with me today, I have Dr. Jonathan Mukete Shoyer, who will be giving the update.
Aloha. May I share screen?
Sure.
Oh.
Go ahead, Jonathan.
Okay. Okay. I was waiting for the okay to share screen. Thank you. The electronic okay. Can you see the presentation?
Yes.
Excellent. Okay. Mahalo. Aloha, everyone. It's a pleasure to be with you again. As Andrew alluded to, part of the water policy plan that the Hawaiian Homes Commission adopted in 2014 included a commitment to regularly and annually and by region update the commissioners and the beneficiaries on the status of key water issues. And so that's what we're doing here today. Very happy to be back with you. Of course, in 2020, we weren't able to do this update. The written submission that you have in front of you covers almost all of this material. So this is just a high-level overview for folks. I'm just going to briefly discuss the different planning regions that are covered, how the department calculates future water demands to fulfill all the land use plans that the Hawaiian Homes Commission has approved after beneficiary consultation. I'm going to review for you the existing water reservations that we've been successful in securing since the implementation of the water policy plan started in 2014, the reservations we have for West Hawaii. And then finally, just conclude briefly on the real core part of the updates, what we're doing to turn our reservations into wet water. Briefly, the three areas, sometimes Humu'ulu region is considered part of West Hawaii, but we're going to be focusing today on Waimea Nui, Kauai High, and Kealakehe La'iopua. This very briefly is a map of Hawaii Island with in tan all the land holdings of the department and commission. And I will briefly go over some of the different regions. This includes all the lands in Waimea Nui, including the lands at Waimanu, all the way to La'Lamilo. This is the Kauai High planning region, the tract that goes from above the Mauka Road all the way down to the ocean. The yellow area in number 2 includes our existing development at Kailapa. These are all the land holdings in the Kealakehe planning region, including lands at Kalaua near the airport, Honokohau, Keahuolu, as well as Kealakehe. And here's a close-up view of some of the villages of La'iopua. So one of the key things we do under your direction in implementing the water policy plan is to make sure we know how much water we're going to need in the future to make our lands, in the words of the Hawaiian Homes Commission Act, always usable and accessible, and then try to secure some reservations for those on the way to securing actual wet water. The way we calculate our demands is we go from the land use designations that the commission has placed in various island, regional, and other plans on the land, and then we use county water demand rates or other applicable demand rates. For instance, the counties don't have demand rates for lo'ikalo, so we go to published studies that show average demand rates for lo'ikalo. The counties don't have average demand rates for livestock, we go to other sources for those. But for single family homes, for commercial, industrial, they have those rates and we will go with those. These rates have been calculated in the State Water Projects Plan, which is one component of the Water Commission's Hawaii Water Plan that's supposed to look at water demands for all state projects, not just DHHL. To update the State Water Projects Plan, starting around 2012, the engineering division of the Department of Land and Natural Resources started to focus on updating DHHL's water needs, which were perceived to be some of the most significant state water needs, as well as ones that are in Constitution and statute called for to be protected. That plan, after extensive work by the department with the Department of Land and Natural Resources, was approved on May 16th, 2017. Since then, the Land Division of the DLNR and the Water Commission have gone on to try and calculate water demands for all other state agencies, and they've done a few updates for us, none in West Hawaii, but for instance, based on our Honokawai planning efforts and other planning efforts, there's some updated numbers. It actually so happens that the consideration by the Water Commission of the latest update to the State Water Projects Plan will be occurring at their meeting tomorrow. We use some of these numbers as the basis for future reservation requests to the Water Commission. The one big difference is that the State Water Projects Plan has a timeline, a time horizon of 20 years into the future, but you as commissioners and essentially as trustees of this trust have a perpetual vision. So we will request water reservations sometimes far in excess of what might be needed in our building plans for 20 years to, again, ensure that water is always available and accessible. When you take all the numbers that we have currently, not including numbers necessarily for all general agricultural lands, based on existing plans, as covered in the 2017 State Water Projects Plan, this is the Hawaii Island water demands for all DHHL lands. From a planning horizon, don't pay so much attention to 2016, 2021, and 2026, so much as year one, our next year of implementing, 5 years of implementing, 10 years of implementing, and then 20 years down of implementing. So, but a total very significant number, 49 million gallons, almost 50 million gallons a day of total demand. So we use those numbers. Sorry, was there a comment or question? Okay. To seek water reservations. And very briefly, I'm going to just cover what a water reservation is, what it isn't, and the existing water reservations we have in West Hawaii. The briefest way of describing what a water reservation is, it's a kapu of water for future use. The Water Commission is supposed to note and defend and protect our water reservations from being used by other users, since we often, due to limited funding, extremely limited funding, can't develop our water and our homestead lands as quickly as we'd like to. This water is set aside for our future use. They can be done in different ways. In established water management areas, like all groundwater on the island of Molokai and most of Oahu, water is reserved for us by rule, and all water use permits are conditioned on respecting our rights. In non-designated areas, which is most of the state, CWRM just takes an action and says, hey, we're reserving this water, but we lack some of the legal protections that we have in non-designated areas that we have in designated areas. Water can be reserved from either surface or groundwater sources, and there's a number of ways in which the commission might start to set aside reservations for the department, the Water Commission. First, sometimes when they're doing certain of their own activities, such as setting a new interim in-stream flow standard or adopting a certain plan, they might decide they need to set aside reservations of water for DHHL, or we might ask them to while they're doing that. When the Board of Land and Natural Resources is considering licensing water under Hawaii Revised Statutes 17158, such as the well-known East Maui Irrigation proposed license, they're actually required by statute to first reserve water for DHHL before disposing of any water to a private commercial entity. And finally, at any time, the Hawaiian Homes Commission and the Department of Hawaiian Homelands may request on its own volition a reservation of water somewhere, anywhere in the islands, surface or ground, designated or not. So that's what a water reservation is. There's a number of things, though, it's not, but most importantly, it's not immediate access to wet water. And sometimes our communities have been like, oh, great, we have a reservation, let's start building. It is a very useful tool, but it doesn't get us all the way there. To develop wet water, we still need, I apologize for the typo, still need a lot of place-based specific combinations of advocacy, capital improvement funds, designed for source, storage, and transmission, any environmental reviews that might be required, as well as agreements for access if the water source is far from our lands and our use, access for operation, and agreements if we choose to have our system operated by the county to agree with the county or any other private entity. Based on the 2017 adoption of the State Water Projects Plan, the Water Commission, working with DHHL staff, set aside groundwater reservations for non-designated areas around the state. So the units that you're seeing with black outlines are their hydrologic units that the Water Commission sets up. And the colored in areas are areas where we have water reservations from the September 2018 action. We also, by rule, from previously, have groundwater reservations on the island of Oahu and on the island of Molokai. And as I'll discuss briefly, we had also secured groundwater reservations in the Keauhou Aquifer on West Hawaii. Since then, we've also secured surface water reservations on West Kauai, as well as from the Wailuku River in Hilo. This is the compilation of all the groundwater reservations we have right now in West Hawaii, as well as the amount we've reserved, the aquifer it's reserved from, as well as the effective date of the reservation. So one thing to take out of looking at this chart is your choice to pass a water policy plan and direct the department on how to implement its water kuleana. One of the chief goals was to secure water reservations, and it's being done. I'm now at the last bit, and I realize you've had a very long day and another long day ahead of you. So just two brief updates. One of the most significant things that's happened in the last year in West Hawaii, updates on Kauai High water issues, as well as updates on North Kona well development for our lands at Kealakehe and La'iopua. Briefly, and this is some of what's covered in the written submittal, the future water needs for Kauai High and Kailapa area include 2.2 million gallons a day of potable water and up to 36 million gallons a day of non-potable water for all our general agricultural lands. We currently only have a reservation for the 2.2 million gallons a day of potable water. In this area, this of course very dry area, the actual development of water is challenging and has been very challenging for the department since its decision in the 1970s to start to develop its lands at Kauai High. Right now, water is provided by Kohala Ranch, which is good because it enables our people to settle on those lands. However, it's provided at significantly high cost. There is a provision in our agreement with Kohala Ranch that allows them to cancel water service with 2 years notice, and there's a limited supply. So for instance, our beneficiaries are not able to use their water under agreements for irrigation purposes. In 2015, through the funding of the department, RM Towell did a study of different options for water development for Kauai High, and each of these rows represents one of the different options. There's a more detailed description in the written submittal on this item, but included using, the department did drill an exploratory well in this area. Unfortunately, even though it was at the same elevation and in reasonable proximity to the Kohala Ranch well that produced nice potable fresh water, this well produced fairly saline water at the edges of potability, and it would need to be desalinated. There's options to run that as our own system connected to the existing Kohala Ranch system. There's a possibility of trying to secure water from a mountain system known as the Kahena Ditch, which actually takes water from state-controlled lands. There's possibilities to expand the existing county Department of Water Supply system, possibly in conjunction with development of a private well. Unfortunately, all of these options are expensive and all of them have certain considerations that will make the further development of water over the long term particularly challenging. I will highlight two things here. The association in Kailapa is on their own trying to secure additional fresh water in a whole number of ways, including they've been talking with some private sector entities recently who might be able to offer lower cost desalination possibilities for use of the existing well. So the department continues to stay in contact with the association on that matter. We also have been in discussions which were initiated by one of the deputy directors at DLNR over potentially securing CIP funds for needed improvements to the Kahena Ditch. The Kahana ditch would also be an area in which advocacy is necessary. It's actually been diverted off of state lands for decades without a lease, which means that, among other things, the department's not getting revenue from the state lease because there is none, and it's not able to get a reservation on that. So that is one thing that we're paying attention to and working on. Finally, briefly in North Kona, as we updated you previously, we've been working with two private landowners at two potentially identified well sites. They're both in the so-called high-level aquifer in West Hawaii. And there's been ongoing regular discussions with landowners, but no agreements or draft agreements have been secured yet for your review. Finally, through the department's advocacy efforts in trying to turn reservations into wet water, when the so-called Ota well, a well being developed by the Natural Energy Laboratory of Hawaii Authority and the Hawaii Housing Finance and Development Corporation, was going through its comment period, the department asked that some of the water in its reservation being turned into wet water as this well is developed by these two entities. As approved by the Hawaiian Homes Commission, there is a memorandum of agreement that would effectuate that right now. The well has not been approved for construction by the Commission on Water Resources Management. It came up before them at their April meeting, and they deferred to address various community concerns that were raised at the meeting of the State Water Commission. Supposedly, they will be coming back in June to consider these matters. With that, that's the end of the overview, and I, of course, with Andrew, are available to answer any questions or receive any further direction. Mahalo nui.
Thank you, Jonathan. Thank you, Andrew. Commissioners, questions for Jonathan or Andrew? That area is a hard area to establish water. Mike?
Yeah, thank you, Jonathan. I'll just a quick question with regards to water reservations. I mean, does it cost? Is there a cost associated with it? I mean, is it a long process to get it, or can you just elaborate or summarize that?
Yeah, I'll give you a brief answer and tell me if you'd like more detail, because otherwise I will run on. It doesn't have to take very long. The starting of getting reservations from the Water Commission took a long time because we actually had to convince them that they had the power to reserve water for us outside water management areas. After years of effort by former acting planning program manager Cleo, Manuel, and I, we convinced them of that. And then it took a while to get the numbers together, but the actual preparation of a request for reservation only can take a couple hours based on the data that we have available. And then it takes a while for the commission to consider it. Longer for reservations by rule. The reservations we're seeking right now are related to, with your authorization already, to the East Maui irrigation system, the proposed lease by BLNR to EMI and Mahipono. And we're also seeking potentially additional groundwater reservations on the island of Molokai outside the Kuala Pu'u aquifer. And we've just finished some beneficiary consultation on that. So there's some effort and some due diligence, but there's no fees associated with it. There's no time limit on how long these reservations can be held. So it's a way of securing the department's water long into the future.
Okay, no, that's very helpful, and I understand it better. Okay, and I mean, there's costs. I mean, if someone's hired to help, with the process,
yeah,
you got that cost, but at least you don't have a fee with the reservation. But then I guess once you start using the wet water, that's when fees get into play, right?
Higher cost to actually develop the water. I will note that if you review the section of the water code in the bound copies of the HRS that talk about reservations, it references a law journal article from the UH Law Journal from 2 decades ago that suggested the failure to get reservations by the department and the Water Commission could be considered a breach of trust. So yeah, there's some cost. It's probably something that we absolutely need to do in any case, and our next steps will be to try and make sure that we have all the reservations for surface and ground that are needed everywhere. And then it'll be a matter of focusing more our attention on actually turning them into wet water.
Thank you, Jonathan.
Mahalo very much, Commissioner.
Russell?
Hi, Jonathan, you mentioned Kauai agreement with Kohala Ranch for water. What is the means of delivery of that? Is that a pipeline, ditch, or otherwise?
There's a pipeline, but beyond that, actually, Gigi, who happens to be on the phone, might actually have a little more knowledge of the technical aspects of it. What I can tell you through my research is that initially, before the department even developed its lands and Kohala Ranch was going through for its entitlements in front of the LUC, initially the state tried to condition Kohala Ranch's entitlement on providing water to us. But the state backed off from that provision, and the actual requirement in the LUC docket for Kohala Ranch just says they have to cooperate with us. So.
And then the concern about them turning off the spigot is that there's more demand than there is supply for water from that source.
Oh, aloha. Oh,
go ahead, Gigi, please.
Oh, go ahead, Jonathan. Oh, okay. Aloha, Commissioner. This is Gigi, Planning Office. Yeah. So our the Department of Hawaiian Homeland's Kauai water system, we are connected to the Kohala Ranch system. It's an interconnection, so they are our only source of water to supply our Kauai homestead. As far as the current agreement we have with them, where the ranch can give us notice, I think it's like a 2-month notice.
2 years.
2 years. I'm sorry, 2 years. 2 years notice to shut off their source to us. Our understanding is, they actually need us. They need our homestead as customers. Just like us, we need more customers on our water system. So we provide them 155 customers, and the more we award leases out there, it'll just give them more customers. So our understanding is there is not a urgency at this time. As well as on their side, they don't have any immediate plans for further developments of their properties. So if there's a concern about whether this 2-year clause is going to be exercised, we do not really foresee that. However, it should not preclude us from, of course, searching for other sources, because you generally don't want any water system to be dependent on only one source. So the department does need to keep looking, for another source, either as a backup to the ranch or as our primary source. That's an ongoing long-term project for us. So I hope that helps.
And then did Jonathan, did you say that although it sounds like we're an important customer or customers to Kohala Ranch, that we cannot use water for irrigation?
That is correct. There's a restriction on the amount of volume. Andrew?
Apologize, I don't remember the exact amount off the top of my head, but there is a restriction on the way the department and its lessees can utilize water. Right now, the department is only authorized to use water for domestic uses and not for irrigation uses.
Okay, thank you.
David?
Yeah.
Oh, sorry. No, we'll go to David first, then Mike. Sorry.
What do we pay, like $8 per thousand or something like that to Kohala Ranch? So I don't know. I mean, it's a lot. Even Kohala Ranch pays their members that live there. They pay that amount. So it's a huge amount of water, money for water. And so I don't think there's any incentive for them to cut us off, because it's a cash flow thing for them. Thanks. Sorry.
Yeah. It's the department significantly subsidizes the cost right now, because we charge our beneficiaries the same as the county rates, which are considerably lower, because the county sets their rates at a blended cost for all 16 of their systems. So while from the perspective of homesteaders wanting to, for instance, garden, it's very unfortunate that their water consumption is limited. From the perspective of the department, that every time a gallon is sold, that it costs us a lot of money. It's not, it has that advantage to it at this time.
Okay, thank you, Jonathan. Mike?
Thank you, Chair. Yeah, so this water system by Kohala Ranch is considered a private system?
It is a PUC regulated, DOH regulated water
Okay.
system.
So it is regulated by the PUC.
Correct.
So if there are any changes to the rates, then Kohala Ranch would submit something to the PUC.
That's correct. And Kalamai.
No. I was gonna say, how often is that done? Is it any particular timing, or I mean, if electricity gets higher, do they submit something in?
I can say that working with a law student with the Kohuliau Center for Excellence in Native Hawaiian Law, we've actually just been piling into those PUC dockets to try and understand some of the history of that. And how do I say this? At this point, just to understand fully to what degree the department and its beneficiaries' rights were considered in the rate setting.
Yeah, I was just curious though, if the power supplied to this water system, is it just solely from Hawaiian Electric, or do they have renewable energy, wind or solar that's supporting the power supply?
I don't know the answer to that. I do know that the entity that's approached briefly the department and homesteaders uses an off-grid solar system to desalinate, to reduce the cost considerably.
Yeah. Thank you, Jonathan.
Yeah, thank you very much, Commissioner.
Thank you, Mike. Any other questions for staff or Jonathan? Thank you very, very much, Jonathan and Andrew.
Mahalo
Appreciate the
for your
Thank
service.
you, Jonathan. Thank you, Andrew.
Aloha.
Aloha. Next, G4.
Commissioners, item G4, just a brief update on the implementation status of various plans related to West Hawaii. Next slide. So as you folks know, the department is guided by its planning system with the general plan at the top and its island plans and strategic program plans at the second tier, and our regional plans and development plans at the third tier. Today, I'll be going over the West Hawaii island plan and the regional plans for Waimea, Waihai, and Keaukehe La'iopua. Next slide. So the Hawaii Island Plan is divided into certain areas, North Hawaii, West Hawaii, South Hawaii, East Hawaii. Today, I'm just going to go over the lands in North Hawaii and West Hawaii. The Hawaii Island Plan was updated in 2009 to reflect additional lands as well as changing land use designations in the North Kona region. Oh, my arrows went off, but anyway, the major changes to the West Hawaii Plan in 2009 were the red area by the airport at the top of the screen on the right map. The addition of that little red sliver down at the bottom, and additional lands in Keaukehe. So those are the major changes. Next slide. This is the Hawaii Island Plan description for Kauai High and Waimea Nui. So this is kind of summarizes what the land use designations are in the Hawaii Island Plan for the West Hawaii. West Hawaii lands consist about 40% of the trust inventory. The majority of it is in pastoral use and also general agriculture use. Next slide. As I mentioned previously, the West Hawaii regional plans, there are 3 in West Hawaii, Kealakehe, Kauai High, and Waimea Nui. Next slide. So the commission adopted an update to the Kealakehe La'iopua regional plan in May of last year, about exactly a year ago. The regional plan identified 5 priority projects. As Jonathan in his previous presentation mentioned, the department is actively pursuing 2 water source developments with 2 private landowners in North Kona. The regional plan also called for additional homestead development for GAP group beneficiaries. And by GAP group, we mean those beneficiaries that don't necessarily fall into low income categories, but also aren't or cannot afford market rate housing off of Hawaiian homelands. So the ask for the department by beneficiaries during the regional plan process was to provide housing for this GAP group. I think Stuart in his future presentation will go over the Village for Rent to Own project. This is for low and to moderate income families. So beneficiaries asked that in future development that we address this GAP group and provide housing opportunities for those that don't necessarily qualify for low income housing. The third priority project that was identified during the regional plan update was a renewable energy initiative. That project is currently in progress. The department did issue a solicitation for its lands in Kalawa for renewable energy. It did receive responses to its request for proposals. A developer was selected from that solicitation, and we are currently working with that developer to provide a beneficiary consultation meeting for the North Kona community. The last 2 projects identified in the regional plan update are currently not being implemented at this time. They have not been started. So the need, there was a need voiced by beneficiaries to establish another district office in North Kona because there is only one district office in Waimea, which is about an hour's drive from Kona. So the beneficiaries in Kona felt that there is a need for a secondary office. And then there was also beneficiaries who advocated that the department develop its lands near Honokohau Harbor for commercial use.
Sure. Yes. Before we go on, Andrew, so you had like a red, green underline for dollars in your chart on page 5.
Yes.
Did we get any money?
I believe we did get money from the legislature. I don't know the exact amount, and I forgot to fill it in before
And let Stuart answer that question.
Oh, okay.
While it's still fresh.
Aloha Commissioners, Stuart Matsunaga again, Acting Administrator Land Development Division. So in this last legislative session, we had a line item proviso in the lump sum budget for La'iopua water development. So we will still have to work with planning to see exactly how we utilize that, because there's also plans for another phase of La'iopua. So I can go through that a little bit more detail in the LDD presentation. Yeah.
Oh, okay.
Yeah.
Okay, thank you.
Okay.
Yeah. So we don't know how much money.
There is I guess we have a lump sum budget with provisos for various.
Oh, that's what you're covering in your.
I'll try to, yeah.
Okay. Okay, thank you. I'll wait then. And then before we move on, so who did we select for the contractor? Was it for the, because I know the association had put forward a developer, right? They wanted to select, was that person selected?
I believe the developer that scored the highest in the RFP process was Nexamp Energy, but we have not reached an agreement with them yet.
And were they selected by Helco for the?
No, Helco's request for proposal process does not occur until later this year. So we're trying to fit our process into Helco's process. So in order to qualify for Helco's process, they need a commitment that they have site control.
Access, right?
Yeah.
Okay, thank you.
Okay, next slide. So the Kauai High Regional Plan was adopted by the Commission in 2010. It also identified 5 priority projects. The Kailapa Resource Center is well in progress. The Community Association has really progressed in the planning, design, and construction of a pavilion and playground on part of its 14-acre site. They are seeking to expand their site to the other, well, let me back up. Their 14-acre site is divided by a gulch, and they've developed on one side of that gulch, and they seek to expand to the other side of the gulch. Because there is a gulch, a major barrier to implementation is trying to get across that gulch with vehicles. So they are currently looking at options to cross that gulch, but they have been very successful in what they've done so far. As Jonathan mentioned in his previous presentation, another priority project was to look at water source development options in Kauai High, because they do pay an extremely high rate for their water. So that was another priority project. Another priority project was the Kauai High bypass. However, since 2010, the department has talked with DOT about its status for the bypass. DOT reports that it has postponed its planning and feasibility study of the project due to the lack of construction funding in the foreseeable future. Another priority project is to improve the marine water at Pelicana Bay and also the nearshore waters of Kailapa. Last month, there was a presentation and action request from the commission to approve a right of entry for the Kohala Watershed Partnership. So we continue to work with the Kohala Watershed Partnership, and we are planning to do a beneficiary consultation meeting towards the end of June to talk about strategies for proper goat removal from the Kauai High Mahupua'a. And then the last priority project, which hasn't started, was the management and maintenance of a reinternment site in Kauai High.
So there's an extra N in there. Should be reinterment.
Oh, sorry.
Otherwise, we might be housing beneficiaries.
Thank you. Next slide. The Waimea Regional Plan was also adopted by the Commission in 2012. It identified 5 priority projects, a community area for the homestead community, evaluate and revise the pastoral agriculture program for Waimea Nui, support alternatives to affordable housing, look at the implications of eliminating the property tax, and also assess the implications of a non-standard building code. All of these projects are in progress except for the assessment of the implications of eliminating the requirement to pay property taxes. The Waimea Homestead Association has completed an environmental assessment for its part of its projects, including an agriculture park and cemetery, they've been able to utilize state CIP money from the Department of Ag to design and construct a roadway into the 161-acre property. They have also constructed water tanks. The department, along with Waimea Nui, has partnered to do the Ag peer-to-peer program, which helped to assist many of the lessees out there to learn best practice farming practices. And then in 2017, the department, when we had the staff, was able to do preliminary research on just the building code process in Hawaii, how the building codes get established, what's the process to amend them. We did attend a couple meetings with the State Building Code Council, but due to the lack of staffing, we no longer are engaged with the Building Code Council on a regular basis. Next slide. So these are the upcoming planning initiatives over the course of the next several months. We are continuing to negotiate water credit agreements with 2 landowners. One of the landowners, I think we're pretty close. We just need agreement on the primary site and a secondary backup site. The other landowner has wanted to take the current agreement back to its council and board, and that's kind of where that is at right now. We also have received funding from the state legislature to do environmental assessment and preliminary engineering studies for both sites, and those studies are currently ongoing, but we await the water agreements before advancing those studies further. And then, as I mentioned earlier, we will be planning to do a beneficiary consultation in North Kona sometime in June or July, but that's to be determined. In Kauai High, like I mentioned earlier, we will be having a beneficiary consultation towards the end of June to consult on best practices or acceptable practices for boat removal in the Ahupua'a. And like North Kona, we will be doing a beneficiary consultation meeting in June and July as well. At this time, I'll take questions.
Questions for Andrew? Okay, I'll ask one more time before we let him off the hook. Any questions for Andrew? Okay, thank you, Andrew.
Thank you, Andrew.
Save those questions for Stuart. Next up is agenda item E1, which is the last agenda item of the day.
Aloha Commissioners, Stuart Matsunaga, Acting Administrator, Land Development Division. Today, we will have several of our young and bright project managers come to the table, and they're working on the projects, and so they can best explain what the status and go forward with that. I do want to say also too that unfortunately our chief engineer Jeff Fujimoto had retired near the end of last year, and so these project managers have been really great in stepping up and picking up a lot of the pieces for those projects as we move forward. Okay, so next slide, please. I'm going to start off with the first several slides, and then we'll pass it over to the other project managers. Okay. So first slide up is the current development at the villages of La'iopua. And the first project is La'iopua rent with option to purchase. That is situated in the lower part of Village 4, Akau subdivision. And so right now, Village 4, Akau, as well as 45 lots within Village 5 are slated for rent with option to purchase. Just last month, Contact and Awards Division assisted the developer in the selection of the first 60 units in Village 4 Akau. Further, rentals are subject to the developer obtaining low-income housing tax credits. Okay, in Village 4, Hema and Sarah Okuda will provide more information on that. Just to the right of Akau subdivision, that is coming up for construction. And again, Sarah will provide information on the budget and the timeline. In Layupua Village 5, current status is that 42 turnkey lots are occupied. 20 lots were constructed through Habitat. 45 will be rent with option to purchase. And then there are 10 vacant lots for offer in the next year through Contact and Awards Division. Okay, next slide, please. Okay, you know, what's in the future? So the near future is to start the environmental compliance and engineering designs for Village 1, which is approximately 200 lots. So subject to the budget, we hope to start that in early part of next year. Village 2 would be again further in the future, about 3 years out, and again subject to funding. These are 200 lots can be accommodated in Village 2. And this is where we are looking at the gap group that Andrew in the planning office was talking about as a priority. And similarly in Village 4 Hema, they'll be offered as vacant lots. And so applicants can, you know, will be able to qualify with whatever they are able to finance. Okay, next slide, please. A little bit more information on the rent with option to purchase project. In this project, the developer, Ikai Kohana, really focused on the low and moderate in the 30, 40, and 60% median income brackets. It was also weighted heavily on the 30s and 40s, and hence that was one of the reasons why I think there was a concern about the 60%ers not having opportunities to select, because again, the project really focused on the lower income brackets. And so tenant occupancy is expected to start in another month or so and continue through the end of December. And in this program, the tenants will have an option to purchase the home that they're renting after a 15-year rental compliance period. And then at which time, if they qualify to purchase the home, then they'll be awarded a 99-year residential lease. Okay. Next slide. This is just an aerial view of the houses under construction. And next slide. Okay, I'm gonna introduce Sarah Okuda, who is the professional engineer and project manager for this project. She's been with Land Development Division for, I think, about 4 or 5 years. And I'm going to turn it over to her for discussion of the next several slides.
Good afternoon, Commission. I'm Sarah Okuda, engineer with the Department's Land Development Division. This first project I'm working on and I'm speaking on today is La'iopua Village 4 Phase 2 Hema. This is a 125 residential lot subdivision. The scope for the project is infrastructure, which consists of lot grading and construction of roads and utilities. Funding for this endeavor consists of $2,789,304 in USDA grant funds. These funds are specifically obligated to water, sewer, and stormwater improvements. There is also up to $12.2 million in legislative appropriations to fund this infrastructure construction. For the schedule, the IFB for the infrastructure construction was advertised in November 2020. Bid opening occurred in March 2021, with the award going to the low bid from NAN Inc. at $13,887,249. The construction start date is to be determined. It is pending funding to execute the contract. Once construction does start, the construction time is 426 calendar days. On the next slide, we have the plan drawing of the layout of the subdivision. La'iopua Village 4 Phase 2 Hema, 125 lots, is southeast of Phase 1 Akau. It is on the southeast side of Ko'oko'olau Street. All the homes, driveways, and access will be through the street. The subdivision is further southeast along Kianalehu Drive, Kianalehu being the southern border, and Nava Street is the eastern border of the subdivision. The next project, Kuhio Village subdivision of Lot 7. The scope of this project was to subdivide Lot 7 into Lot 7A and 7B, to install water laterals and also install a new fire hydrant. The construction cost was a low bid of $74,170 from NAN Inc. However, some of the costs were allowances that wasn't used or needed, and the final cost came out to $45,582. For the schedule, construction was completed in August 2020, and the final subdivision documents were sent to the State Bureau of Conveyances for recordation in February 2021. And the third and last project I'm speaking on today is Pu'ukapu Pasture Lot subdivision of Lot 22. This is a subdivision of one lot into two like the previous project. The drawing there shows how the lot will be divided into Lot 22A and Lot 22B as a flag lot in back of Lot A off the roadway of Poli'ahu Alanui. The scope consists of subdivision mapping and water lateral improvements. The cost is $31,964 in professional engineering services. That's RM Tao's current contract to complete the design and subdivision, and an estimated construction budget of $50,000. The schedule for design, the surveying work is being scheduled to begin within the next month. Construction is estimated for early 2022, and the final subdivision will follow construction completion. That's it.
Thank you, Sarah. Before I get on to Galbert Yoshida, I want to say, Kalamai, I skipped over the water development portion for La'iopua. And so for La'iopua, we did receive as part of the lump sum appropriation of a total of $50 million, a proviso stating approximately $12 million for La'iopua water development. And so that still needs to be, I guess, vetted out. Not all of the funds have been identified by provisos. So that would be one of the projects that we can use for furthering North Kona well development. So I think that looks good. That also looks good for furthering the Laiopua subdivisions within the master plan.
So would it fund the well development, then, the 12 million, or is some of that money earmarked for other?
No, it could fund the well development. We do go through a process to request release of the funds through budget and finance and the governor. So I'm sure we can write it up and justify for that. So LDD would be collaborating with the planning office to make a specific request when the monies become available.
So it sounds like we would be close to getting that done one way or another, right? To get
That is, yeah, that is correct. Yes.
very good.
Yeah. So not all the funding is going to Maui, but a substantial amount is, so. Okay, in fact, there are other provisos, and we'll be happy to share that with you when we talk about the budget next month. Yeah. Okay, and just one note on Sarah's discussion with Phase 2 HEMA. The funding to execute this contract has already been budgeted. So we are going through the process of requesting the release of funds from budget and finance and the governor. So it's very close to being executed and then the contract being encumbered. So I just want to share those notes. And so next up is Kelbert Yoshida in Land Development Division, and I'll let him take it away.
Good afternoon, Kelbert Yoshida, Land Development Division. Just wanted to go over some of the work that is being set up for West Hawaii. So the slide is showing the Pu'ukapu road repairs. We have an estimated budget of $400,000. The project will go out to bid after we do a community notification and make them aware of the improvements that are being set up in the invitation to bid, hopefully out by September 2021. This Ni'e project, Punono Road improvements, was based on flooding that had occurred. I think was from Hurricane Lane passing through the island, and whatever spilled over caused some flooding on the roadways. So we did the project to improve certain areas with concrete pads to let the water drain and not erode the roadways, and also include clearing of some of the existing storm drain pipes. And it was supposedly based on a FEMA request to get this work done, and hopefully we can apply for FEMA reimbursement. Our Honokowai non-potable water system is contracted out with Ishimoto Contracting. This is part of that settlement agreement with Waiola Honoko'ia. The water system is to supplement individual catchment systems. Hopefully, when the project gets started, the implementation would be to put in 6 miles of pipeline for non-potable stock water with 100,000 gallon tank for 42 lots. The construction cost was $1.3 million using a former Board of Water Supply tank that was shipped over. And the maintenance will be done by the Waiola Honoko'ia nonprofit to operate and maintain the system. we are still in negotiation with the County of Hawaii on assurances to provide water quality and the connection and pressure issues that are faced with some of the lessees. Not so much the Honokoia side, but one of the residents in the Kamoku homestead. That's our point of connection. This is Lalamilo Phase 1, Kauai High Road. The improvements there was kind of designed for in 2013. And it's slated for improvements. We had a contractor on board and the work stopped based on UXO requirements and getting license agreements to relocate 7 utility poles. And that was kind of dealing with SIC, Hawaiian Telecom, and Oceanic Cable, now Spectrum. This job has been completed. Lalamilo Phase 1 inspection ports. In the Phase 1 development of the lots, the 37 lots didn't have inspection port over the seepage pit. So that was constructed and put in last year. So work was completed July 2020. Cost the department $179,500. Lalamilo Phase 2, increment 1 is where we planning to start up the soil testing. That was kind of a big stop for us back in 2015. And we finally got that clearance and assurance from Department of Health. A lower tier testing would allow us to investigate what type of soil conditions there are and create the buffer zone for the residential lots. So as you can see on the slide itself, we have commercial areas designated in the yellow and then open space in the green. And hopefully that creates our buffer area for the resident lots in the middle. And while that is getting ready to start up, we continue with the UXO testing and monitoring of the increment 2 for future development.
Okay. Thank you, Calbert. I just wanted to say that both Sarah and Calbert have taken on a lot of these projects that have been, I guess, had a lot of challenges, and they're moving them forward step by step. There continue to be challenges, but they really are aggressive in getting this work done. The Pukapu non-potable water system has been in place for approximately 10 years. Over the years, things happen. The liners have torn. There's been mechanical issues, and so the last year or so, we've been making repairs and improvements to the pump, the solar PV, the tank liners, and what has most recently happened is this installation of these bypass tanks. So these will also add to the capacity of the system, and so the bypass tanks will carry the water while the tank 3 liner is being repaired. And as we speak, the liner is being repaired, and the tank is gonna be refilled, I think, in the next week or so. So we also intend to look at a management and operations overview study, since the system has been in place 10 years and is in need of some improvements going forward, and at least having a plan to address different things like breaks and shortages. So that's in progress. Next slide, please. And I'm just going to share some other projects where we have collaborative work with Homestead Services Division, with Contact and Awards Division, and with NAHASDA. We have 2 standing inventory houses in Lalamilo Phase 1. Lot 9 and Lot 16 will be undergoing appraisal by HSD and coordination with CAD, Contact and Awards Division. We also have 5 vacant lots, and thanks to the efforts of Calbird, we had the inspection ports installed and the aerobic septic tanks tested, making sure that they hold water. They were constructed back in about 2007, when Lalamilo Phase 1 was first being constructed, infrastructure construction. So these will be made available for award shortly. So we'll coordinate with Contact and Awards Division for that. And next slide, the last one is our Kauai High residential habitat lots. There are 5 lots. And this one is funded through NAHASDA. And so it's the HUD ER was recently completed, and NAHASDA is working with, that's not a botanist, that's a botanist, for site inspections to make sure that the environmental compliances are addressed, for nesting, nene, bats, birds, etc. And so, again, collaboration with NAHASDA, with HSD, and appreciate all those efforts. And also thanks to Planning Office for basically setting the stage for LDD implementation. And without those plans, we really can't do much. And with that, that's, yes, open for questions.
Okay. While you think about and formulate your questions, I just want to thank the LMD staff, the junior members, as they're described by Stuart, for stepping up and taking on more responsibility because of retirements and not being able to fill those positions right now. So we do appreciate the efforts that they're putting in to pick up these projects that have been left by other engineers and carry them over the finish line.
Mahalo, Stuart,
Go ahead.
and your staff.
Go ahead.
No, I just wanted to mahalo Stuart and his staff. We don't know what we'll do without you guys. Amazing. You guys are amazing.
Yep, it's it's a staff every month, used to come here and talk about all the great projects and successes, and it's with a full team effort in Land Development Division and collaborating with Homestead Services, Planning, NAHASDA, Land Management, and then supported by ASO and fiscal to make sure pay the bills, certify the contracts, etc., and get the money from the ledge. So without all of that, we really we won't be as successful as we would be. I hope I didn't forget anybody, land management. Okay. And ICRO, because ICRO helps get the word out for LDD. We're not great talkers and communicators, and so ICRO helps us with notifications. And so please, the website is so robust now with a lot of activity going out, and ICRO helps us with all of that messaging. So mahalo.
And another thing, Stuart, thank you so much for the support you provided for the island of Molokai with the Polihua water system project that's going on. And kudos to the district office staff. They're very limited in manpower, but they go full broke, those guys. So I just wanted to go out and say thank you to the staff, and even Mona, Mona from Maui. I like to thank Kapu. Thank you, guys.
I know.
Hey, Zach, I'll make one quick announcement, and that is we finally received permission to fill the district manager on the island of Molokai. So that was one of two that we've been asking for more than 4 or 5 months. And so we have a land agent and the district manager on Molokai that we now have permission to go out and fill.
Thank you. Wow.
Any other questions for Stuart or any of the staff? Okay. Stuart, thank you very much. If not,
commissioners,
that brings us to the end of today's agenda. I will recess the meeting and we will return tomorrow morning at 9:30, I believe, right? Okay, we're now in recess.